Good morning. Good morning. Today is Tuesday, May 6, 2025. It is 8:30 a.m., and I'd like to call to order this meeting of the Tennessee State Board of Accountancy. Notice of the May meeting of the Tennessee State Board of Accountancy, including date, location, and time, has been properly noticed, and a copy of the agenda was posted to the Board of Accountancy website on Tuesday, April 29th, 2025. Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on the provided sign-in sheet, which is at the back of the room, or by placing their name in the chat box online. It's requested that comments be limited to 3 minutes out of respect to others. Karen, at this point, I would ask you to to perform a roll call to confirm a quorum.
Greg Gilbert.
Present.
John Griesbeck.
Present.
Pam Church.
Present.
Sam Bennett.
Present.
Andy Bonner.
Present.
Brad Buchanan.
Present.
David Crenshaw.
Present.
Brad Floyd.
Present.
Kevin Monroe.
Present.
Rob Vance.
Present.
Thank you very much. I would also like to welcome any visitors we may have today or members of the public. I think we may have some folks who've asked to comment during the public comment period. I don't see any visitors in the room at this point. Maggie, you're not a visitor, but you're on the governor's staff. Thank you for being here with us. I also would like to acknowledge that this is the last meeting at the end of 3 consecutive terms of service for Dr. Pam Church and Mr. Kevin Monroe. And Pam and Kevin were each appointed by Governor Bill Haslam with subsequent reappointments made by Governor Lee. And we will talk more about your terms later in the meeting, but just wanted to acknowledge that on the front end and thank you both for your service. And a board appointment to fill the seat vacated by Mike Parton is still pending. Also, I would like to remind you that NASBA is currently seeking accountancy board members for 2025 to 2026 committees. An email with links to apply was sent from NASBA on March 25th, 2025, with a reminder sent on April 16th, 2025. So if you have not been involved in NASBA in the past, I would encourage you to consider doing so. I think certainly each member of our board would be giving and sharing your vast knowledge with NASBA, and NASBA would be most appreciative. And I think you meet some very interesting people and learn even more about the profession. So I would encourage you to participate. Finally, I would ask board members to please remember to turn your microphones on when speaking and off when finished. Our system allows up to 4 mics operational at any time, but beyond that, who knows what happens. So we may not hear your comments. At this point, I would like to entertain a motion to approve the agenda for today.
I'll make a motion.
Motion's made. Do we have a second? Second. Those in favor, aye.
Aye.
Those opposed, no. Thank you. Dr. Pam Church, it is time to approve the meetings or the minutes from our last meeting. Do you have any comments?
Yes, Jen had sent me the draft of the minutes, and I did note some items that I thought should be expanded due to the important topics we discussed last time, including mobility issues and the self-sufficiency hearing, et cetera. And so those were expanded, and the minutes stand approved by us, Jen and me.
Thank you. So I would entertain a motion to approve the minutes.
So moved.
Second.
Second.
Those in favor, aye.
Aye.
Those opposed, nay. Thank you. And Pam, thank you for being thorough in reviewing those minutes. That is very time consuming, and so thank you for doing that. And
Sure.
Jen and Karen, thanks for all the work that you do regarding those also. Next on our item is an executive director's report. Jen, meeting number 2. Glad you're here.
I'm still happy to be here. Thank you for having me. I will give you my report at this time. You had a copy of it included in your pre-meeting materials. You'll see at the top of the report, we have future meeting dates, board meeting dates of Tuesday, July 29th, 2025, Tuesday, October 21st, Tuesday, February 3rd, 2026, and then a new proposed date of Tuesday, May 5th, 2026. So we can hold action on that until the end of the report. Upcoming NASBA meetings, NASBA is holding NASBA U next week, Wednesday through Friday here in Nashville. Their office is in Nashville. That is a gathering of new executive directors across all 55 jurisdictions, where I believe the purpose is for NASBA to just give us an introduction and a welcome and explain more of the services that they offer to boards. We have the Western and Eastern regional meetings coming up in June. I believe that most all members who are interested have already let me know who would like to attend the Eastern regional meeting in Philadelphia. Just as a reminder, our budget allows for 5 board members to attend. We also have the 118th annual meeting coming up in October in Chicago. So if you know now that you are interested in attending that meeting, please let me know so we can plan for it. Back in March, the end of March, Duke and I attended the Executive Directors and Legal Conference in March in Clearwater, Florida, a conference put on annually by NASBA. State Society CEOs were also invited and encouraged to attend. Kara Fitzgerald, our State Society CEO, attended virtually. The conference was a wonderful learning and networking opportunity for board staff. I put a list of notable conference topics here. I will say it truly was an eye-opening, wonderful learning experience and networking just with other state executive directors, listening to the things that are going on in their states, building relationships. It was a great opportunity. So some of the things that were discussed at the conference, updates from other regulators, including the Office of the Chief Accountant of the SEC, the PCAOB, the IRS, Department of Education, the Department of Health and Human Services. Those presenters gave updates from their respective departments and shared an overview of how they engage with boards of accountancy. There was a report provided on ongoing NASBA activities from NASBA Board Chair Maria Caldwell, as well as Dan Dustin, President and CEO. In addition, we heard an update on UAA and legislative matters from NASBA leadership. There was also a NASBA-led discussion on alternative practice structure, firm ownership, and regulatory impacts from that. NASBA legal and compliance staff provided an update on legal matters and enforcement tools, including several case studies involving regulatory boards. There was a panel discussion on navigating relationships with societies and legislators. And there was also an overview discussion of peer review oversight committees and peer review in general. I have attached CPA exam performance reports provided by NASBA for Q3 and Q4 of 2024 for reference. And I'll echo what Greg said about NASBA committee interest. NASBA is currently in the planning stages for setting up 2025, 2026 committees. If you're interested in being on a committee, emails went out in March with a reminder in April with links to apply. And they have said if you were serving on a committee last year and you intend to continue on with that committee, they still ask that you reapply for that committee. In regards to CPA license and firm permit renewals, this will be a repeat from what we communicated in February, although the renewal period we're still winding it down. All firm permit holders and even numbered licensees received a renewal postcard via U.S. mail in early November. Renewal notices were also sent via email on December 11th and January 16th. For licensees and January 22nd for firms. Licenses and permits renewed on or after January 31st incurred a $100 late fee. Board staff will send a final reminder in June prior to license expiration for those licenses still in expired grace status. And as a reminder, any licenses that are not renewed after June 30th go into expired status, and those licensees and firm permits would require a reinstatement after that. I've listed some of our team's performance metrics for Q1 of 2025. These are department metrics that our team is held to help ensure that we are a customer-focused government. So our average number of days to license, you can see there, our goal in accountancy is 7 days, and we met that for 2 of the 3 months. And then I think this was mentioned in the committee meetings yesterday, but our case and complaint performance goal is to have 90% of our cases closed within 180 days, and we met that metric, or we're pretty close to it in Q1. And then online adoption rate, our goal is 80% across the division, and we have 100% online adoption with our accountancy licensees. We've also included some data that you can review for new licenses issued for Q1 2025 and previous periods, as well as our overall licensing population. As of the end of March of this year, we had 12,042 active CPA licenses, and we had 1,708 active firm permits. That concludes my report, and I'm happy to answer any questions.
May I make a comment?
Yes.
I think this is the appropriate place for me to say this, Jen. She knows what I'm going to say. When she sent these results out, I wrote back and asked, could we get the pass rate showing what percentage of individuals pass all 4 parts of the CPA exam the first time? I assure you, students ask that regularly, as does the general public, and I think it's an important metric that reflects entry into our profession as we discuss that broader issue. And not coincidentally, she was going back through some old meeting tapes, and lo and behold, she found where I had asked for this, I think, last year, and I think I've asked for it the year before and the year before. But there was a pause in at least the data release, according to school, et cetera, and it looks, we're back up to full force on that. So she has said she will ask about that. I don't think it's enough we've had individuals with ASCPA who'll say, oh, well, that's about 20%. I think it should be tracked. I really think it should be tracked. So as I rotate off the board, somebody else can pick up that cause, but I think it's important.
Yes, I've asked NASBA for that data, and I know that it's something that they can provide. I just need to work with them to get it. So I can add that into my reporting going forward.
Thank you, Jen. Thank you, Pam. Other questions or comments? Okay. Jen, thank you again. I mentioned this yesterday, but thank you and Duke for attending the NASBA conference. As I mentioned also, I had the opportunity to review the agenda, and there were some really important topics discussed and presentations made, and so thank you all for taking the time to attend that. I think it's very helpful.
Yep. Before we move on, can we vote on the future meeting date that was in the report? I almost forgot.
Yes, ma'am. I was getting ready to do that. But
Okay,
that's
thank you.
Perfect. So we have a proposed meeting date, and do we have a motion to approve the director's report, including the meeting date?
I make a motion.
Motion's made. Second?
Second.
Second. Those in favor say aye.
Aye.
Those opposed, no. Thank you. Karen, just double checking, we do not need roll call since we have 10 members present, correct?
Yes, that's my understanding, only when someone is voting remotely. Do we
Okay.
need a roll call?
Thank you. We now move to the legislative update section of our agenda, and I believe, Lee, are you doing a presentation for us at this point, or?
Oh, yes, sir. Yes, sir.
Sorry.
Yeah, would you like me to start that?
Yes, sir.
Okay, the big issue in the legislature is the Less is More Act of 2025. That piece of legislation addresses a number of boards and programs in Tennessee, including accountancy. And the bill makes 3 significant changes to the requirements for CPA licensure in Tennessee. First, for persons applying for their initial CPA license, the bill opens a second pathway to licensure. So applicants may now be licensed by either showing 150 hours of education, 1 year of experience, and passage of the CPA exam, or in the new pathway, 120 hours of education, 2 years of experience, and passage of the CPA exam. The second change for CPAs who are already licensed in another state but now wish to move their principal place of business to Tennessee and obtain licensure in Tennessee, and this is known as licensure by reciprocity. Those applicants would only have to show that the applicant is licensed and in good standing in the applicant's state and that the applicant has passed the CPA exam. I would note the applicant would no longer have to show that the home state's qualifications are substantially equivalent to Tennessee's qualifications. The third change, for CPAs who are already licensed in another state and wish to expand their practice to Tennessee without having to apply for a Tennessee license, and this is a privilege known as mobility, the CPA would only have to show that the CPA is licensed in good standing in the applicant's state and that the CPA has passed the CPA exam. So again, I note that the CPA would no longer have to show that the home state's qualifications are substantially equivalent to Tennessee's qualifications. This is Senate Bill 1316 and House Bill 1330. I think the most recent action out of the General Assembly is to substitute the House bill version as the current bill. The Speaker of the House has signed it, and but it has not finished the process of passage in the General Assembly. It's certainly well on its way.
Thank you, Lee. Jen, do you have any comments or anything to add in this section?
I think Lee summarized it well. Essentially, we will have two pathways to licensure, and this is just recapping what Lee said. We'll have two pathways to licensure. What will stay the same is we will still require a bachelor's degree for licensure. The first pathway will remain the same, the bachelor's degree plus 100, to include 150 hours. Well, 150 hours to include a bachelor's degree, sorry, plus 1 year of experience, plus the CPA exam, and then the second pathway, as Lee said, will be 120 hours to include a bachelor's degree, plus 2 years of experience, plus the exam. I don't have anything to add. I know that we will continue this discussion in later parts of the meeting, but yeah, I don't have anything to add. We can also give, in addition to the legislative update, one thing I had asked Lee to speak on as well was an update on the peer review rules that started last year.
Yeah.
You want to give an update on that?
Sure. The governor's office has completed its review, and the peer review rulemaking packet has now progressed to the Attorney General's office. The Attorney General has assigned staff attorney to it, and I'm working with that staff attorney on the rulemaking packet. There are a few punctuation and kind of stylistic edits that might occur, but there's nothing substantive that would need further board approval.
Thank you, Lee. Questions or comments?
Mr. Chairman, I've
Yes,
got
sir.
just a question for Jen. Jen, since this new legislation is probably going to pass and is well on its way, I believe was the statement, for firms and individuals that just have 120 hours in that degree, I believe in the past Tennessee has allowed those people to go ahead and sit for the CPA exam. Is that correct?
So that's a good question. So applicants can apply to take the CPA exam before they have their degree in hand, but you must have that bachelor's degree in hand in order to sit. That is in statute, and in this legislative session, that statute did not change.
Okay. So the second part of the question is that for those who are in accounting, either in public or private, this would be an opportunity, and I believe you said that the law will change on 1/1/26.
That's
Is
when
that
the new
correct?
pathway goes into effect, yes.
Do you think that's maybe an opportunity for them to go ahead and start sitting for the exam if they do have that diploma in hand? Because we may have lots of people who work at firms that just never went back and got their CPA certificate.
Yeah, we've started getting that question to our office already. So
Really?
if you have if you meet the qualifications to sit for the exam, meaning you've got the bachelor's degree and you've got the accounting concentration as defined in rule in order to sit for the exam, which is a little bit lower than what's required for licensure, then you are eligible to go ahead and sit. And then assuming that this is signed by the governor and nothing happens before then those applicants will be eligible if they meet the requirements under the new pathway on 1/1/26.
Well, that is quite exciting. Thank you for that information.
Mr. Chairman, I have two questions.
Yes, sir.
One for Jen and one for Mr. Lott. So the first, Jen, to you, just remind me for the verification of employment or experience, is that any licensed CPA in Tennessee can sign, regardless of whether or not it's 1 year or 2 years?
Yes, that's not changing. And I'll clarify too, it can be a licensee from another state that can sign that experience verification.
Got it. Okay. And then, Mr. Lott, for you, just help me make sure I'm connecting the dots correctly. To the extent that the package changes or the law changes, how does that affect the peer review discussion we had yesterday? Again, in the case where you have a licensee practicing in Tennessee for whom the current or their home office or their home state does not require peer review, does that, maybe I'm not connecting those dots, but does that sort of make that issue moot yesterday, or would that still be a problem?
No, sir, I think those are two separate issues. The one yesterday had to do with practice, whereas this today has to do just with, let me add to that. The personal jurisdiction and the ability of the authority in one state to impose some type of discipline on a citizen of another state would be unchanged by this bill. And that was really the question, I think that was before the board yesterday. Today, it's really about the kind of qualifications to have reciprocity, or I guess mobility would be the issue here. So it's qualifications versus practice. I hope that answers your questions. Your
Okay,
question
so
on
if
that.
someone has practice privileges by virtue of mobility in Tennessee, they're licensed in a different state that does not require peer review. If they are issuing an attest report in the state of Tennessee or for a Tennessee-based client, then again, this rule package in front of what presumably will go in front of the governor does not change the requirement that that individual would still be, or that firm would still be subject to peer review.
That's correct. And let me see if I can word it a little better. The issue yesterday was whether we can impose discipline on someone who is licensed in another state. The issue in the bill is whether that person can do mobility at all.
Okay.
Yeah, and the changes to the mobility statute will not change the fact that anyone practicing in Tennessee under mobility, they're still subject to our jurisdiction.
Okay.
That won't change.
Thank you.
Thanks, Brad. Good discussion. Other questions or comments?
Mr. Chairman,
Yes,
one
sir.
other comment, and we may reprise this in our NASBA discussions later, but just for awareness, so we have a couple of things out there in the ether relating to this issue. One is the Uniform Accountancy Act revisions that are on the verge of being presented back to the boards of NASBA and the boards of the AICPA, which provide for a little more detail around this that we may need to consider and have the legislature and the governor's office in the future consider to ideally try to get some conformity. And then secondly, in late breaking news, we've become aware that the state of Florida has proposed legislation that would radically alter the requirements to become and remain a licensee, at least in Florida. Among other things, for example, eliminating continuing CPE requirements has been circulated among the proposals going forward, and effectively eliminating education requirements in terms of sitting for the exam, potentially. That has not passed yet, but if something like that happens, by virtue of going away from substantial equivalency to individual mobility, this legislation now puts us at the mercy of the lowest common denominator of other jurisdictions, perhaps to the disadvantage of resident Tennessee CPAs. And that's something that I think we in the legislature, and my hope is that the governor's office of the future will consider, and we'll have more clarity on that, I think, when the UAA is finalized, and we'll have kind of a footprint to look at, and we can modify it. We don't have to follow it. It's a choice. But I think we'll need to carefully consider that in view of what states like Florida are currently contemplating.
And if you allow me, Mr. Chairman, I can actually add to that and just say that yesterday during our committee meetings, NASBA sent out the UAA exposure draft and the recommended changes to sections 5 and 23. And we're actually going to have a board meeting this week to actually vote on that and accept it. And so that should help kind of bring everything together under the UAA as far as a standard mobility. And the hopes are then, once you see the NASPA report from me today, you'll see how mobility kind of looks right now, and it's all over the place. And so the hopes then are that everyone will go back and take a look at mobility and bring it back into a common way as before.
Thank you, Mr. Monroe. You're correct regarding possible implications from changes that other states may enact. So if you think through Florida's situation, what might having no requirement for continuing education, how does that affect peer review? And I researched this over the weekend. I couldn't remember, but I checked it. For membership in the AICPA, a member must have 120 hours over a 3-year period. And so how does that affect AICPA, and how will they react to that? So just a lot of questions that will come up. Thank you. Other comments? Okay. Lee, thank you so much for that presentation and update. At this point, we will move to our board committee reports, and Dr. Church, your committee is first.
Thank you. We have 4 cases where people have asked for some sort of exception. I would like to go through each one and give the facts, but then hold the voting to consider all 4 together if the members of the licensing committee have no objection to that. The first one is Gabriel Brin, who's requested that the board consider a 2-month extension for reg and audit scores from an expiration date of 6/30/25 to 8/31/25. He is requesting this under the regulation that allows for exceptions when a circumstance is beyond the person's control. He is under current treatment for a medical condition that has been documented by a doctor and has been noted to be one that we have granted extensions for. So the committee moves that this be approved. Is there discussion? All right, the second one. Is Michael Montgomery, who actually did attend part of our meeting yesterday. He had requested that the board consider an extension of reg and BEC from an expiration date of 6/30/25 to 12/31/25. Under that same stipulation, that people can ask for an exception if there's a circumstance beyond their control. His is a little different in that when he finished his Master of Accountancy program in May of 2020, he had accepted a role with an accounting firm, but then was furloughed. We noted that this was right in the middle of COVID or the beginnings of COVID, and things were quite unusual, and we felt like that furlough was beyond his control. So needing to find employment, he actually went into an investment banking role and pursued that a while, but realized that his experience there would not qualify for CPA experience, so he stopped taking the exam. But now he feels like he wants to go back to that path and is going to work for a CPA firm, and has said that he feels like his situation is the same sort of undue hardship that other extenuating circumstances impose. And we agreed and used that rationale to recommend that Mr. Montgomery's request be accepted, approved. Is there discussion on this one? The third one is Samuel Laws. The same situation, the same regulation that he's requested under. He's requested an extension of his reg score from an expiration date of 8/6/25 to 12/31/25. A little bit in the future there, more so than the others. He's also passed TCP with an expiration date of 12/27/26 and is not requesting an extension there. He suffered from a heart condition and required surgery and has submitted the medical documentation from his doctor and hospital visits. So we felt like that certainly was an extenuating circumstance and moved to approve that. Is there discussion on that one? And finally, this one is a little different. This candidate, Semplice Zariga, had requested that we consider acceptance of his foreign transcription evaluation completed by WES as a qualification for licensure. Now, WES is a transcript evaluation service, and when he's been a resident of Tennessee since 2006, but his bachelor's and master's degrees were from Ivory Coast University on May 16th, 2007, and he was approved to sit for the CPA exam in 2008 by NASBA with this evaluation from WES of his international credit. So any international credit has to go through some sort of a service like this. Let's see, at the May 4th, 2021 meeting of our state board, NASBA and board staff had concerns regarding how WES was treating education received in India, and specifically WES found India's 3-year degree program to be equivalent to a 4-year degree program from an accredited U.S. institution, and NASBA and the state board believed that treatment was not consistent with other evaluators or the board's rule. The transcripts as reviewed by WES and submitted by Mr. Zinga indicate that his bachelor's degree was completed in 3 years, but he does meet the 150-hour requirement for licensure, and that specific point was noted yesterday. And it appears that his accounting credit hours are 4 hours short of the 30 hours, but again, he was approved back in 2008. So we felt like we had granted him permission to go down this path. He has been taking parts ever since. And now that he's passed, we believe that we will move that this be approved. Is there a discussion? All right, since there is no additional discussion, we're ready for a vote, and we can do this by voice, I believe. So all those in favor of approving all 4? Is that right, Karen? I can say all 4.
Yes, ma'am.
If you approve of all 4, please say aye.
Aye.
Aye. Opposed? All right, thank you. That concludes our report.
Thank you very much. And just a point of order, the motion came from the committee, so it does not need a second. So I think we're good with the vote. Correct, Karen? Thank you. Mr. Griesbach, laws and rules?
Thank you, Mr. Chairman. As noted in the February meeting minutes, the Law and Rules Committee discussed the discipline matrix that the board operates with. It was actually last done, revised in October 23. After that discussion, the committee requested that Mr. Lott explore how penalties, particularly for peer review violations, are computed, the basis, and how we might consider any changes there, and also provide input as to how the board could consider imposing administrative and investigative cost in addition to civil penalties as applicable. We also asked Mr. Lott and Ms. Binkley to recommend any changes deemed necessary, in their opinion, to our discipline matrix. So yesterday, we further discussed these same items. Mr. Lott discussed the peer review violations and the fact that they're per day and, per violation. And I think we had a good discussion there, and I think we're pretty clear on how those are being imposed. It was also very clear that the board is not limited by that discipline matrix in situations where it feels like a penalty beyond maybe those stated penalties is required. And we talked further about that. We also discussed, Mr. Lott and Mr. Johnson, the issue about imposing legal and administrative costs to respondents in order situations where penalties were imposed and, trying to recoup some of those. The discussion, I think, at this point, or feeling, was to continue to consider this on a case-by-case basis, that we do have the right under the statute and rules to impose such penalties or additional cost to the penalties. And then finally, as far as tweaking the matrix, we think we want to continue to do that. Ms. Binkley and Mr. Lott agreed to take another look at that. Mr. Monroe brought us up to date, provided some good historical perspective from the board's history as far as when this matrix was developed, sort of its genesis, and the idea that a key goal was consistent application by the board in penalizing violators. And so I guess at this point I would say, just to summarize and as we move on, that we would ask Mr. Lott and Ms. Binkley to consider the matrix. We noted in our discussion maybe some changes or revisions, additions to the narrative related to this, and the fact that the board can consider other things well within their rights. So if you would do that and get back to us at the next meeting, we would appreciate it. Is there any other discussion or comments that anyone would like to make related to that discussion?
Mr. Griesbeck, I think that, after hearing the discussion yesterday and the summary today, that, I really am looking at our attorneys and our legal cost associated. I went back in and looked at, year to date, we've got $97,000 now. Some of that is related to the fact that we have cases that are brought before us where we don't have jurisdiction, or the facts aren't there and we close them. But as a ratio, it does seem like that once we do have a case where a proposed discipline is there, we've had our investigator involved, we've had our legal team involved, and that from my understanding, the state allows us to go back and allocate those costs to not only our matrix of disciplines, but just the cost of providing those services. I don't think that's a service that really should be borne by the CPAs across the state, but I do think it's a service that should be tagged on as a percentage of some way, shape, or form to the proposed discipline of the people who are doing the wrong things. And so I would like us to consider applying that to, to the proposed discipline as some kind of calculated set cost that we come up with, whether it's just the cases through the year, and that are closed and versus the cases where proposed discipline is, and then that ratio, come up with a ratio cost of some way, shape, or form to allocate that to the proposed discipline plus the cost for those services. That's just my personal opinion. I just think that it's not right to, if we get to a point where those costs are getting large, and I'll say that, we have a great legal team, we have a great staff, they do a fantastic job, that we could not be sitting here and going through this report that Mr. Monroe is going to bring forth without that team, and we're very fortunate to have them. But when you start talking about the cost of that, I think it's the people who are doing the bad things that should bear some of that cost, in my personal opinion.
I don't disagree, and probably a lot of us might not disagree. I guess the key point is going to be, how do we do that? On what basis? How do we allocate? Is there a minimum charge? If you think about the cases we consider every quarter, probably roughly half of them are consent agenda with no penalty. But obviously there's administrative time and investigative time on those. So I would think those would probably not get a charge for anything. And so I would open it up to any further thoughts on Mr. Bonner's comments.
I agree with Mr. Bonner's comments, and I do think it's appropriate that we consider allocating some costs to some of the cases. Personally, I think we should do that in conjunction with Mr. Witcher and his department. I see he's with us today, and thank you, Reed, for being here. So I think in accordance with policies of the governor and the Department of Commerce and Insurance that it would be appropriate to do. If you look at our financial statements for the last few years, we've continued to incur additional legal costs. And who pays for those? It's either the licensees or you could make some argument that the general public. I know in the past a few times that the reserve fund of the Board of Accountancy has been swept into the general budget, so to that extent, taxpayers. And the third option would be the people who are violating the rules. And so to whom do we allocate those costs, and what's fair, what's equitable? So again, I would be for allocating some of those costs to people who we issue fines. But again, I would want to do that in accordance with the rules of the Department of Commerce and Insurance, and not at all get at odds with our friends there.
I think those are good comments. Any others?
I will just add on that I agree with comments made. My view of this is that it likely is borne either by the CPA holders or the general public in some fashion. And those that have caused or perpetrated the wrongdoings should bear some of the costs. I appreciate the comments yesterday around the extent to which you try to impose those, or the magnitude might have some bearing on whether or not people will quickly resolve the matters or not. So I think there's an element of that. But I always have two comments. One would be, I think we should consider it and maybe have some sort of commentary, proposal, right? Such that it is then, it's something that's out there, something that is known to the public or can be made known to the public. That would be one. The other is with reference to the matrix that we discussed yesterday. And this is maybe one of just sort of emphasis. It doesn't, as I reread the matrix after the meeting last night, notwithstanding this potential $1,000 a day concept, the wording of that matrix does not come across to me as such, meaning there's a greater potential that we may choose not to, but there's a greater, as I understand it, there's a greater potential for us to levy higher penalties than what we are currently doing. If I just take, for instance, an issue of a review report inappropriately again, I think there's probably varying views on this panel, right? But you might say each review report constitutes a potential $1,000 penalty. I could also make an argument, I think, that each day that review report exists in the public inappropriately, that one report could potentially have $1,000 fine each day it stands. So my point in saying that is I do think that there is probably something that we could do to make it known as part of this process that the penalties that we charge or that are charged are in some sense much lower than what they could be otherwise. And that might just by itself help to have a deterrent effect. If someone knows that if I issue a review report, for instance, well, maybe I'll take the risk if it's $1,000, if I know it's $1,000. But if I know it could be $10,000 or $20,000 or something much more substantial, that might by itself curb some of this behavior that we're seeing that none of us, that is inappropriate and that, again, is subject to these fines. So that's this is my reaction to that conversation yesterday, and I think we could advertise that. First, I think we could advertise that the penalties could be higher, and that might, as I said, have some deterrence on actions that occur.
Thank you, Brad. As I've heard these comments, a couple of things that stick out. One, Mr. Gilbert, your comment related to the department, I think that's going to be key. There's a number of departments and a number of them that face these similar issues. And so it really, in some ways, is sort of beyond us right here as part of a bigger picture. So I think we have to be really cognizant of that. And then Mr. Buchanan's comments, I think, related to commentary and the public and, sort of educating them or, that knowledge out there is probably very important. And I guess the third issue is just going to be always, how do you do this? How do you go about this? I think we all agree the people that are violating are getting a free ride as far as the costs are concerned that we incur to impose these penalties. And, we understand from the discussion yesterday the sort of elements as part of an investigation to where you get to maybe there's an order and the order's, settled okay. And if it's not, then you go to a hearing, then there's additional cost incurred. And, the comment was sort of, okay, maybe that's when we do this. But I think I'm hearing that that's not necessarily maybe the thought of a lot of folks, and that, when we get to the order, we consider imposition of some charges, fees at that level. It feels like what I'm hearing, and then figuring out how to do that. So I think we have to sort of, in my mind, kick it back to legal and to the department maybe for some guidance here as to, what might be appropriate within the constraint to meet the goals of the state and the department, the regulatory boards under which we operate. Any thoughts?
I have one thought, please. From my understanding from legal, and this pushback is not the right word, but I guess explanation was that well, first of all, none of the other regulatory boards impose costs at all. So we'd be the first one doing that, if I understand that. And secondly, how is that going, since the fines and all that we see here are settlement proposals, that was an excellent word. Thank you for bringing that up. I didn't really think of it that way. How is that going to affect us being able to settle these effectively, quickly? And do we have any sense as to how, is it going to blow up the process and all of a sudden we're going to have 10 hearings a quarter? Do we have a sense for that?
I can speak on that topic. I think first, when I'm hearing the discussion on imposing costs and investigative costs or whatever it may be, when you're in the settlement stage, they have to agree to that, to the consent order. So I think the risk is, like you said, you could see more hearings happening if they don't agree to those costs. And in turn, that bumps up the legal costs, bumps up potentially investigative costs. And then you get to a full hearing, you've got all the authority to impose all those costs after a hearing. You still run the risk of there being a judgment and it being uncollectible, and then all those costs are still not paid for, which in this profession that may be not as common. Hopefully they would pay the judgments, but I think that's the risk that you take if you want to start imposing costs at the settlement stage. I think a lot of them would agree to it. They may not turn their head, but I think we could look at the investigative costs and maybe, I think they're probably similar in each case, but I think we would have to have Duke keep up with his time and put it in his reports. That way we have a log, and we have to back up what we are putting in, offering in these consent orders. So I think we can definitely do this, and we can see how it plays out. I do want to clarify that other boards are imposing costs at the hearing stage. It's definitely not common for boards to impose costs at the settlement stage. So most boards will look at that, or currently when a hearing takes place, and they will assess everything they can as far as the filing fees with the administrative courts. That's a couple $100, and then the administrative judge costs is where that gets really high sometimes with a hearing. They're $1,000, $1,500 more, so that's other stuff you have to consider. But they will impose all those costs at the hearing.
Well, I would think the real expense is in your time, the legal time. Don't we have the ability to impose an hourly rate for your time? Also, I mean, that I would think that could add thousands of dollars to just about every case. I mean, that's where the real cost is, or the legal fees.
And if
so,
sorry, go.
No, but
If it gets to a hearing,
do you keep your hours so that we would know that?
typically, if we are going to a hearing, we will start keeping our hours, but that's really the only point from upper management that we've received to start keeping our hours. So it's definitely not common to impose the legal cost at a settlement stage. I think I would definitely steer you towards maybe just the investigative costs.
Which is not
any other
great, really. I mean, it's the legal, I mean, like I said, it could be thousands of dollars per case. So that's just my thoughts on the cost accounting of it. But I agree that the normal CPA population shouldn't be, or the non-violators, which is 99.9%, shouldn't be paying for the 0.1%.
Yeah, and I think we can come up with cost allocations if that's necessary, but, I think in terms of a $1,000 fine, and if we bump that to $1,250, so $1,000 plus $250 of costs, I can't imagine that a large percentage of our folks would not agree to those consent orders, because they already do at the $1,000 level. And, I'm not, from my perspective, I'm not talking about a $1,000 fine and $3,500 of costs associated with that, but something at least reasonable.
I would just add to that, not a concern, but we can't be arbitrary about it, so we'll have to look at it case by case. I think you could come up with a standard $250 or whatever it may be based on what the investigative costs, but we can probably start recommending that, what the standard we want to impose, but we will have to look at what the actual costs were. That way we've got a basis for it, and it's not arbitrary or anything like that.
Mr. Chairman, one comment on top. I agree with the comments that Andy put forth, and I like Brad's commentary around different ways to interpret the per incident, because I think it sounds to me like all of the board members would agree that the $1,000 fine, if it's intended to be a deterrent, that seems very insignificant in relation to the fees that were potentially charged, for the engagement that led to the violation. And so, from my perspective, I understand that we can't be arbitrary in how we divvy out, civil penalties, but where there is intent or there's recurring violations, or there's just negligence, it seems like we could be much more aggressive to ensure that the penalty matches the crime, right? So I guess my comment is, I don't think that $1,000 for the issuance of a review report is a very strong deterrent, right? It's probably worth the risk to not get the peer review, and potentially risk a $1,000 fine if my engagement fees are, $15,000 or $20,000 for that review report. If I knew that, to Brad's point, that it could be interpreted as, $1,000 per day, or $1,000 per use, or, per third party that report is distributed to, right? There's a number of different ways that you could potentially interpret it. That deterrent becomes, much more significant, right, in relation to my engagement fees. And so I think it all comes back to, again, making the penalty fit the crime. And if the penalty is just a very, very small fraction of the fees that can be earned by perpetrating the act that results in the penalty, it just seems like it's not a deterrent, right? So whether it's the way we interpret the $1,000 per instance, right, if it's per day or per, report, or whether it's, allocating the legal costs, of the, that are incurred in direct response to, to the wrongdoing. I think there's got to be, I think, a little bit more teeth in the potential penalty if we want it to really be a deterrent.
And it feels like over the last couple of years, a greater realization that we're having more of this recurring. Some of the cases we've dealt with, and I think as we went through this matrix thinking, okay, maybe the $1,000, that's why I wanted to look at peer review, but in some instances, maybe there is suspension and revocation where it's particularly egregious. And so it feels like the mindset is sort of elevated towards that direction, because of the type occurrences, incidents we're seeing. So I think that our awareness is, raised to it. So I think that's good. It feels like some data could begin to accumulate in terms of investigation, hours and, potentially legal within the guidelines of the department, in the direction from them for us to consider as we go forward. So I would suggest that we begin that process as we can, and as we go into this next quarter and board meeting, it would be helpful to maybe have some of this commentary that Brad mentioned, from the staff and the board, and even from the department, if that's appropriate, to give us a little bit more information, I think, to consider this. Because certainly, like I said, our awareness is raised, the issue is becoming more acute, it feels like, and it's a good time to begin to consider how we address it, to reach that deterrent.
Mr. Chairman, I just offer one other comment from a bit of a different perspective. We'll see when we go through the legal report that virtually all of our proposed discipline cases are with respect to issuances of review or compilations reports without either a firm permit, peer review, or both. And so I think there's great credit to the contractor licensing board for consistently referring to those violations to our board so that we can take appropriate discipline. But there is a mechanism, I think, to try to get at preventing some of these so that we aren't imposing fines because people aren't violating the rules. Just as we did a few years ago with respect to CPE violations, where we were getting CPE audits that were showing a 30 or 40% non-compliance rate, and we tweaked the rules to require upfront reporting and a little more work on the front end by the licensees, and now we're down to something like less than 5% non-compliance in terms of our CPE audits, which has been a tremendous improvement. And so my hope would be we could work with the Contractors Licensing Board to try to maybe front-end the detective process for rules violations, so before the reports are submitted and then rejected appropriately by the Contractor Licensing Board, we can try to find a way to head that off at the pass and keep people from making mistakes. We'll still have some deliberate violators that we'll have to deal with, but the discipline that we're about to go through is not out of the routine for our board. You know, our two biggest historical violations by number have been CPE audit failures and review reports issued for purposes of the contractors licensing industry that the board does its homework on, their board, and dutifully passes on complaints to us, and then, of course, we do our job. So I would like to see us put as much effort, particularly on this cycle, into the preventive side and work collaboratively within the department and within the rules. We can't dictate to the contractors board. We don't want them dictating to us, but collaboratively, ideally, we could work together to try to work out a system that will head some of this off at the pass and minimize the angst and agita for everybody. That would be my hope.
Yeah, I agree totally. You know, at the end of the day, it's our board's licensees that are violating here. You know, even if you check the box, and we check boxes for CPE and people still don't have their CPE, and they may check a box to say they've got a permit and a license and peer review and everything else. But I absolutely agree if we can have that collaborative effort. And I'm very thankful for everything they report to us. They've been very diligent about that.
I'd like to add to Mr. Monroe's comment just to say it would protect the public in Tennessee if we did that, if we could come together, because of the fact that, you know, contractors are coming out and saying, hey, I've got to have this report, and all of a sudden they've got time invested in waiting for the report to be done to get the license, and then all of a sudden they find out they can't get a license, and now they are delayed, so it costs them money. And so it would help out the Tennessee contractors, in my opinion, and it would also catch the bad players at the same time. So it seems like it would be a win-win for both parts, and reduce the cost at the state level. Just a thought. The other thing that when we were sitting here talking about this, and Kyle, I believe you said, you know, if we can collect the fee. I know yesterday in committee, we had a proposed discipline on a person who had been assessed a discipline and had agreed to it, and it had not been collected yet. What do we do with people who do not pay those fees or those disciplines? Do we monitor that? Do we go back and look at them? Do we have a method that we go through to try to collect that money, or do we just say, well, they didn't pay it, we didn't collect it?
I can take that in two parts. I think you got to separate it. If it's a licensee and they say they've agreed to a consent order with a payment plan and they default on that payment, according to that consent order, usually their license would be immediately suspended until they, and actually that whole amount would have to be paid in order for the license to revert back to active. But non-licensees, if they agree to a consent order or it gets taken to a hearing and a judgment's issued for a $5,000–6,000 civil penalty, we usually give them an opportunity to pay it, send a demand letter, and if it's still not paid, it ultimately goes to collections. If it's over, and don't hold me to this, but I think if it's over, it's either 10 or 25,000. Those are sent to the AG's office, Attorney General's, to collect on those.
In the agreements, to go further, in the agreements where we have a collection agency do it, do we actually, in the agreement, write in that if it's not paid, then any and all collection costs will be added to that? Or are we netting a lesser amount because we're having to cut that fee with a collection company?
I'm not certain on that. I have to get back to you. I mean, we basically just direct the collection agencies to collect this whatever the civil penalty they agree to and hasn't been paid, or what was assessed at a hearing. I think you're getting at maybe the costs associated with the collections, what we have to pay. I'm uncertain on that, so I can get back to you on that at a later date.
If we don't do that, is that something we can add into these agreements so that in the future, that if somebody, whether licensed or unlicensed, then they bear that cost for not performing as they agreed to?
Again, I'm uncertain. I'm not sure if that would be, if those costs are associated with the department as a whole or this board. So I think it would depend on, or this board specifically. So I think it would depend on that. But I will certainly look into that, and I can report back to you.
Okay. I'd like to add that to the agenda item, that for them to report back, Mr. Griesbeck, to let us know, because that would definitely be something we need to consider if that's not being done, or if we can do it, or.
I will add, I don't think that's very common with board. Fortunately, I think if someone has agreed to a civil penalty or they get a judgment at a hearing, those are most of the time paid. So I think it's a rare circumstance. I think, like the discussion yesterday with the one outstanding penalty. So I think that's a good thing. I don't think it'll come up a lot, but I'll get back on that so we know how to handle that in the future.
Well, with that statement, can we add also the fact that if we can know how many people are in that same position that have not paid a penalty, since it's so rare? Do we have 1, 2, 10, 20 that haven't paid that are under that 20,000 or 25,000 limit?
I'm uncertain of that number. We can get back to you on that. And then I would actually separate it out. Hopefully, we don't have any licensees that have an unpaid penalty. We may, but we can report back to that. I think most of them you would see are probably non-licensees that have committed unlicensed activity. They're just, don't care about it, thrown it under the rug, and haven't done anything.
Do those unpaid fees, do they accrue interest? So
I'll have to get back to you on that too. I'm
that would be,
not sure.
that would just be another deterrent for not paying, right? Just the fact that it's going to grow over time and you're going to have to deal with it at some point.
Yes, correct. That definitely would be a deterrent.
Any other comments, questions?
May I make just one last comment, please? I know we're robust discussion. I don't mean to cut it off, but it seems to me that this contractor license issue is very simple. And I remember Mr. Gilbert bringing this up, I don't know, a number of meetings ago, because we seem to discuss this fairly often. It would seem to be quite simple, as long as it's not a law or a regulation change on the contractor board side, if we could convince them to add to their application process the fact that when a review report is issued, the CPA firm has to give their peer review certificate or whatever. I haven't had one in so long, I don't know what that's called, where you're approved, you've gone through peer review, and the TSCPA or whomever gives you that certificate. Okay, can that not just be part of the application process, that you get the review report and here's the certificate from the CPA, and then it's done? That's the preventative nature of it right there. It's done, because if they don't have it, they go, oh, why don't I have it? And then they can't apply. The application never goes through. It seems to me that's just a internal process, part of the application process.
So this has been an ongoing discussion. I work with the contractors board as well. We've got some stuff in place with some proposed rules that will hopefully hit it right on the nail, what y'all are talking about. So I can report back to you and see how, hopefully you'll see a decrease in the amount of referrals. We've got some stuff in the works over there, and I can certainly relay the discussion as well from here to.
Well, we have like, what, 8 of these? I mean, that would drop to maybe 1 or 2, right? I mean, and your time would be considerably reduced. I don't know. It just seems to be a simple solution to that, but thank you for doing that.
No problem.
Rob, that was one of the my first questions with the contractors board, my first month here. And after looking at their applications, I think it sounds like a simple fix, but there are more complexities involved with changing their application to include that. So we're having the conversations internally. It is something that is important to that board as well as this board. And we'll continue to keep this board apprised of any changes that happen with their application.
If you just sell it to them, it's going to make their jobs a lot easier too, because they don't have to go through 2 applications now. Once they reject A and A comes back to them in 3 months with a new review report, their work's doubled as well or tripled. I mean, it would seem to be a win for everybody, but thank you.
Go ahead.
I would just add, I agree with everything, and I think this discussion has been ongoing for a little bit. So we have got stuff in place that is going to hopefully take effect, that is addressing everything that you guys are commenting on.
I mean, for what it's worth, I would add that, accountants have to do this in many cases with federal agencies as audits are submitted, so it's not an uncommon practice, and I agree it could be a really good deterrent. So I guess unless there's any other comments, and I appreciate everyone's comments and questions and thoughts here, we can kind of wrap this up. If the staff, Mr. Lott in particular, and Jen, consider some of the type things we talked about on the discipline matrix, revising some narrative, adding some comments and things that would fill in maybe some of the questions out there in terms of when things apply, and some of the things that we can actually impose in terms of suspension, revocation for just about any, I guess, violation almost in theory. And you went through a lot of things, Mr. Lott, in terms of a lot of the actions that we can take, penalties that can be imposed, not just civil, money type penalties. If we could work on the data that could form a basis for how we might consider charges in the future at whatever stage of the process. And I agree with some of the comments in terms of practicality. We're not looking at a $3,000 fee on a $500 fine or penalty. And so we have to be, reasonable there and not arbitrary and what have you. So I think those are important. But I think this whole discussion is timely and relevant. It's an important topic. Having said that, I know the staff is got plenty of things to do, in their daily roles and legal and working with other boards and all, but we do appreciate any, insight, we could have on that would help. It would really be good at some point if we could develop, I'll call it sort of a working paper, I think Brad said commentary. That's kind of what I envisioned, some of the pros and cons, some of the things that we have to consider, because, you guys as legal know things of how this works that we don't necessarily. And then I guess finally, just in terms of how this fits in with the department in general and other regulatory boards and, the administration's desire to, recoup potentially some of these costs that maybe aren't being recouped at this point. I think it's important that obviously we operate within those confines. And so, again, that's guidance we have to look to you to provide us, but certainly appreciate everything you provide and the efforts you've made so far and all the board members for their discussion. So at that, I would turn it back over to you, Mr. Chairman, unless there's something I missed or if there's something we'd like to add.
No, thank you, Mr. Chairman. I will also tell you that I've had some conversations with Jen about the matters that we run into with the Licensing Contractors Board, and Kyle, I hope you understand that most of the people on this board are CPAs, and so we're looking at ways to reduce costs. That's by nature. And we see tremendous costs in this back and forth between the Contractors Board and our board and your department, and we think there are ways to eliminate those costs very efficiently and easily. So that's the perspective that we have on it.
Thank you for that, and I totally agree. I just want the board as a whole to understand some of the things to weigh when making that decision. So we can definitely report back and start taking the considerations and in our recommendations with costs and updating the matrix and stuff like that.
And as Mr. Griesbach mentioned, it's the CPAs that are violating, not the Contractors Board, but maybe there's a way that we can remedy this to some extent. Okay, thank you again, Mr. Chairman. Kevin, would you mind to lead us through the Enforcement Committee?
Thanks, Mr. Chairman. The Enforcement Committee met yesterday afternoon, and we reviewed the case and complaint report, which is an information item. No action is required. But just to summarize, we noted that the staff of the Board of Accountancy, including investigative and legal counsel, has been doing a great job of throughput with respect to the complaints. Virtually all of the historical complaints that are aged, if you will, have been placed in litigation monitoring for systems or things that are beyond our control. And when you take that and set that aside, the processing of complaints is proceeding generally well within target for the department, and so appreciate staff and legal's efforts for that. That was an information item that was reviewed. In terms of our legal report, we typically divide our cases into buckets. One bucket is called the consent items. These are items where discipline, such as in the form of a civil penalty, is not recommended. It may be for closure due to lack of jurisdiction, closure due to lack of evidence to open and proceed with a complaint. And then the second bucket are those cases where we are proposing discipline with respect to the licensee, or in the case of unlicensed activity, the non-licensee. So what we're going to do first is address the consent item cases that are in our agenda. Those are the first by report numbers 1 through 11. I'm going to separate out case number 5, which was a discussion case that was initially recommended for a letter of warning. But during the discussion yesterday, the committee voted to recommend to the board that we change that recommendation to discipline in the form of a civil penalty. So we'll deal with that one separately. So right now, we're going to focus on report cases numbers 1 through 4 and 6 through 11. In each of those cases, the recommendation is to close either on the basis of lack of jurisdiction or insufficient evidence. In one case, item number 6, recommended to be placed in litigation monitoring because it needs to basically develop in the face of pending civil litigation or action. And then we have one case with a letter of warning. I'm sorry, we have 2 cases in terms of litigation monitoring. And then one case where a letter of warning is being issued with respect to due care on the part of the CPA. So in each of cases 1 through 4 and 6 through 11, the Enforcement Committee recommends to the board that we accept the recommended outcome of either closure or placement in litigation monitoring or letter of warning. So that is the committee's recommendation to the board, and I'll stop and open it up for discussion. Hearing none, I'll Mr. Chairman, ask for you to call for the vote here.
So we have a recommendation from the committee. It, again, needs no second. So those in favor, say aye.
Aye.
Those opposed, nay. Thank you, Mr. Chairman.
Okay. Thank you, Mr. Chairman. We'll now deal with case number 5. And this was a good discussion point on the part of the committee and other board members that weighed in yesterday. This morning, I think council passed out a revised version of the legal report. Just want to make sure everybody has that for us. And so the original recommendation in this case was to close with a letter of warning. This was a case where a review report was issued. This is a Board of Licensing Contractors referral. However, in this particular case, the review report was issued on a Tennessee-based entity, but the firm issuing the report was from out of state. And so we had a discussion here. There was no question that a violation of board rules occurred in this particular case, but the discussion was around should an out-of-state CPA receive a more beneficial treatment in the form of, in this case, a letter of warning, as compared to what we would normally impose upon an in-state resident CPA who issued the same report on the same Tennessee entity. And after discussion, it was the committee's recommendation that there should not necessarily be a difference in how we would adjudicate this. And so the committee is now recommending for this one that we authorize formal charges for violation and a settlement offer via consent order with a $750 civil penalty. So that is the recommendation of the committee to the board for this, which is a difference from the original recommendation presented by staff and council yesterday. So with that, I'll open it up for any questions or comment. I would just note that, even under mobility, when CPAs come into the state and are working on Tennessee-based engagements, they need to comply with Tennessee rules. It is noteworthy that in the state of jurisdiction for the CPA who is performing this work, not in Tennessee, that state does allow for reviews or compilations to be performed without peer review. Our state does not. But since the entity for whom the review report was done was in Tennessee, and since it was for the use of the Tennessee Contractors Licensing Board in part, we determined that there shouldn't really be a difference in terms of the type of approach for discipline. Any further comments or questions? Mr. Chairman, I'll turn it over to you to call the roll.
So, case number 5, correct, Mr. Monroe?
Yes, it was.
So, case number 5, do we have a recommendation from the committee? Again, needs no second. Those in favor say aye.
Aye.
Those opposed, no. Thank you, Mr. Chairman.
Thank you. So what we're going to now do is proceed to the proposed discipline cases, which are cases 12 through 20. Cases 12 through 19 all relate to referrals from or complaints opened as a result of contractors' licensing board referrals for review or compilation reports that were issued without by a firm, either without a firm permit, without peer review, or both. And I think most of the recommended disciplines here are pretty standard in terms of our disciplinary matrix, and were not controversial as we discussed them in the committee yesterday. But there is one particular case, and that is case number 13, where the committee, with board member input yesterday afternoon, recommended enhanced discipline, we'll say, or proposed discipline. In this particular case, we have an unlicensed CPA whose license was allowed to expire and has been in expired session for, or status for some period of time. It was expired for non-renewal back in 2013. In this particular case, this respondent was a subject of a prior case as recently as 2024 for issuing a review report, essentially in an unlicensed state and without, of course, having a firm permit or being enrolled in peer review. The board adjudicated that case in the prior year and entered into a settlement agreement with this respondent that involved paying a civil penalty in the amount of $5,000. The respondent signed that consent decree. And here we are in 2025, and we find that subsequent to that activity, the respondent is alleged to have done the same thing again within the space of a year. And furthermore, he has not paid the previous civil penalty that he agreed to pay of $5,000. And so after discussion, and the recommendation that we have in the revised version of the legal report, just through an administrative error, does not include what we had agreed upon to recommend, which was to require completion of the 3-part NASBA ethics course on the part of the respondent if he elects to ever reinstate his expired license. But in this particular case, the committee recommended authority to commence formal proceedings against the respondent to settle the case via consent order requiring the respondent to pay the above described civil penalty of $5,000 and requiring respondent, if he ever seeks reinstatement of licensure, to complete all conditions for reinstatement pursuant to Board Rule 0020-01-.10, in addition to all of the normal conditions for reinstatement of an expired license, including but not limited to CPE penalty hours. We also authorized and directed counsel to bring the information in this case to the attention of the Attorney General or other appropriate law enforcement officer as described in Statute 62-1-114. And then I would add here, and if seeking reinstatement, to complete the NASBA 3-part ethics course. This is a case where we have a repeat violator who is thumbing their nose at the board's actions and the agreement they made in a prior year and is continuing to exhibit this behavior. And so I think the sentiment of the committee was to really attempt to deter behavior like this again from this person or from others. And so that is the revised recommendation for item number 13. And since we made a change to that from the original recommendation, Mr. Chairman, if you're comfortable, I would just propose that the board vote on this item singly and then discuss and vote on it, and then proceed with the other proposed discipline items.
I agree
In a
with that
separate motion.
approach, Mr. Monroe. Any discussion on this case? The committee discussed it yesterday, as did some of the board members, of course. So at this point, we will vote on the committee's recommendation. All those in favor say aye.
Aye.
Those opposed, nay. Thank you, Mr. Chairman.
Okay, thank you, Mr. Chairman. So what we're left with are proposed discipline cases 12 and 14 through 20. 12 through 19 relate to Contractors Licensing Board referrals, as we just discussed. Case number 20 was an actual audit report that was issued, and the complaint was brought through the Comptroller of Treasury's office, where we had an audit report that was issued with no firm permit and no peer review. And so in each of these cases, we are basically authorizing follow-up and settlement with a consent offer and civil penalty for, depending on the various nature, amounts of violations. Some of these had firm permits, some did not. One was a compilation, the others were reviews, and the one audit. So the committee respectfully recommends that the board accept the disciplinary recommendations for cases 12 and 14 through 20 as recommended by the board from the committee meeting yesterday.
Good. Any discussion? Mr. Monroe, I do have a comment. Let's see, I think it's on number 14. Just something I found interesting. The very last paragraph before the recommendation, aggravating factors for the board's consideration include that in the most recent license renewal, respondent answered in the affirmative that they completed the Tennessee-specific ethics CPE course. Despite that, the respondent still was unaware of the requirements to provide a test services. We're all human beings and we all make mistakes, or at least I do, but I have trouble understanding that disconnect in this case. And I'm not proposing any change on the recommendation, but it's just an interesting situation.
It is, and one of the things, again, we talked earlier about trying to get on the preventive side of things instead of, or in addition to the detective side of things for violations. And the board has worked with the Tennessee Society to emphasize in our Tennessee state-specific ethics course, what you may and may not do without a firm permit and without a peer review. And in fact, in our audience is Dr. Perry Moore from Lipscomb, who is just one of the renowned state ethics course teachers or facilitators, and also has helped the board in terms of developing content for the course. But this has been a point of emphasis for several years, in the hopes that maybe we are heading off at the pass some of these items. But whatever we can do. I was smiling at the end of Mr. Griesbeck's conversation, and I wanted to say there are probably more than a few board members that would be willing to crawl over broken glass, to try to resolve these contractors' board issues on the front end. And this was another small effort to try to do that, and we'll keep trying it.
Thank you. And also we have Kara Fitzgerald with us, who's CEO of the Tennessee Society of CPAs. I know Kara has been very instrumental in helping draft the programming for the ethics course.
That's
So
right.
It's just, and we know that content is in the course, so it's just amazing to me that folks attend that course and are not aware of these rules. But nonetheless, I'm off subject a bit, but we are approving case 12 and 14 through 20,
Yes, sir.
correct? Okay. Any further discussion? Those in favor of approving the recommendations, say aye.
Aye.
Those opposed, nay. Mr. Chairman?
Thank you. That concludes the Enforcement Committee's reporting.
Kevin, thank you so much. Again, outstanding work, as we have discussed time and time again. Another birdie putt today, by the way. Just teasing Mr. Monroe. The next item is the executive report, and I think we have two items that Jen will present for us.
Yes, so included in your board materials, you will see travel detail for board staff from the first quarter of 2025. Duke and I attended, as I mentioned earlier, Duke and I attended NASBA's annual conference for executive directors and board staff and legal counsel in March. So you will see travel costs and conference fees associated with that, that conference, as well as Duke's travel for the board meeting in February. In addition, I included a snapshot of our board's financial statements through the first 9 months of the fiscal year. And my commentary there would be that our licensing revenue is on track, I believe, with where we had budgeted it to be. You'll see, consistent with prior years, the bulk of our revenue comes in November, December, and January, with renewals happening during that period. And our expenses, specifically our cost backs for legal, centralized complaints, customer service, as well as our admin cost backs, are trending favorably compared to budget. So I do anticipate that we will come out at the end of the year very likely in a deficit and consistent with prior years, but it hopefully will be smaller than what we had budgeted. And I'm happy to answer any questions that the board might have.
Questions or comments? Okay, thank you, Jen. I
Thank
think
you.
we have no action items under the executive committee at this point. I do think at this point it would be appropriate for us to take a break, maybe 15 minutes. We still have a good bit of agenda items to cover, and so let's take a break. Maybe back at 10:15, that's okay?
David, your family well?
Pam, excellent report as always.
Thank you.
season.
Sorry, it might be your last.
It's soccer too.
I realized
Always
after
something at your
Kevin did
kids'
his
ages.
that,
Everybody's
oops,
ready
I
to be
guess
out
the
of
chair
school
was
and we're
supposed
gonna
to
head down
call
to
for the
the
votes, but I think they're legal.
Yeah, everybody's good.
I think we changed it.
Congratulations.
Number 12.
It still passed.
It's interesting to see
just makes your
what
dinner time just go up and
expands
up.
and what contracts,
Kids are
you
good,
know,
12
because I
grandkids are
thought
good, spouses are all good. so-
Kevin's report might be longer and
Yeah.
John's might be shorter.
Yeah.
We've had some weird weather.
That's
I'll tell you what, it was a month ago, we had 14 inches of rain in 4 days.
It took any of the storms.
Which ones?
A couple rounds up here.
Well, we just had
Add a single
monsoon.
line to the
I mean, it was
form.
what I call a generational rain.
And we talked about this,
like
I think,
They
6
said at the
months ago.
airport on that Saturday.
Or you could add a
Wednesday to Saturday.
checkbox, like the applicant has to go,
Oh, okay.
they give them a link to say,
Check with your CPA.
go here
As long as they can keep it.
and see if you see this person listed. And check, and that's
I'm about ready
a
to
condition of
start building
application, like,
And
make the
I
applicant
think
do
you're
it.
on the next time,
Might be
not
about
this time.
time.
I think
We
you're on
had,
the
I couldn't believe the
suggest-
federal income tax extension we got with.
That person,
shocking
the
to
applicant
me.
has
I
a
mean,
vested.
on April
Absolutely.
14th.
I know.
I think it was.
And look how
Every
much
county
time
in the
and
state.
money is wasted.
That was different. Didn't they
And
get
the
the same
contractor
for
board.
Really? Same day?
Interesting. Okay, well, I was scrambling that day. As
Consider it sort of
You would
treasure.
think they would be spearheading this, so they wouldn't be wasted.
Well, they may not feel like they have the
They did,
authority.
I've heard several instances where people said, oh, gone, I
Thank
just
goodness we
submitted
got
my
crossover
return.
council.
Who knows? What are you gonna do?
That's what you get for being early.
But at least, the estimates aren't even due till November.
Yeah.
So that's pretty nice.
Yeah, that's nice.
But, yeah, I just could, every single county in both states.
I guess they didn't want to go into a county by county determination.
I guess so. That'd be hard to do. Hard to do. That was pretty broad-based and pretty liberal. I mean, it was, that was 7 months, I think. Or something.
I was very surprised. In fact, when my personal CPA called me and told me that, I thought he was joking. It's like, that's not a funny joke.
Yeah, because, we've seen them in the past, but I don't ever remember what on April 14th. So many times it wasn't a situation you could take advantage of something. Sometimes it was, clearly, but.
Have you ever crossed paths in Memphis with Mike Casper. His firm. He's a Belgian Baptist guy, but he has his own firm. 25 facilities. I want to say it's Casper Associates, but I don't know. He might have a partner too.
Yeah, that's awesome.
I know they do a lot of dealership work and that sort of thing.
We skip personal name with that. What if he came out of another firm that did a lot of dealership?
Okay.
I don't know. He's got 3 sons, all of which graduated with me at Tennessee. Just on the phone.
Well, I have a friend who's in South Korea.
ECS family.
He was telling me that.
My kids all in NCS.
Oh, okay. I bet there's some crossover somewhere.
But his, I'm sure his is a lot younger than mine.
They would be mid-40s to mid-30s.
What's the skill level? So you've got like all these guys.
The
Kids.
oh, okay.
I think the average score at the club's like 5 or something. You're not moving very quick. Yeah, exactly. It's not a 4-hour round.
Another firm that did dealerships.
Mike and Debbie Casper.
I actually like the rental
Is
clubs
it-
that get over there because of course, you know, it's all.
KASBER?
Right, so like,
PAR.
PR. Okay. All right. All right. Wait a minute. You know the kids' names?
Kevin, Jason, Steven. Steven was the real good ball player that wouldn't play ball at.
Little kids. It's stiff and title clubs better.
Kevin and Jason were great athletes too. They go play.
Okay. Now I don't know if it was his family or another one where one of the sons was involved in a big storm
And Jackson, that was Jason.
in Union.
Yeah.
Okay.
His machine fell on top of
Okay. I know you're talking about this.
Yeah.
Yeah. And
Yes.
because
Yeah, hospital for
I
a couple
think
hours.
So are you,
Jason,
are you
was he the oldest?
Middle.
So we've got, yes, we've
Okay,
got
he's
standalone
either,
financials in the US.
he was
that
similar
basically
age, I
puts all
think,
their
maybe to
revenues.
mine.
We've got reporting from.
They
They
are
are 6 or 7
My
countries. So
oldest
they
son,
are registered, they're not a
I believe,
registrar. They've got
48.
debt, they've got debt at the US.
Now, my youngest daughter is
So we've got separate standalone here and then we also.
we had 2, and 10 years later we had 2 more. And so, how old would he be?
He would be, I'm gonna guess, 37, 38, somewhere in there. I don't think he's 40 yet.
Well, somewhere in there, one of them crossed paths, because I remember that very specifically. Yeah, when that happened, and he was like trapped or something.
Yeah, they had to
So are you
pull him
a
out.
showroom?
Yeah,
Non-integrated?
that's right. I remember that for sure. And I thought he was maybe in class with one of my kids.
CPA, okay. We've also got a separate JSOX.
We had, my son and I went down to Alpine Camp. I don't know if you know Alpine.
Very well.
Oh, okay, all right. There was a lot, we were in a cabin full of ECS folks.
Well,
Dads.
tell you my Alpine story. My younger son, he's 30, born 89, so he'll be 36 this year.
How does that work?
And
So that's why we do it as the AUP, because it like
counselor for
Yeah,
3 years. Head counselor the last year. And he's actually a minister. And he went back after he got married with his wife and served as a minister. One summer. Yeah, so this has been about probably 8 years ago. But he is, Alpine is, our kids never went there. So I only know about it through him. We'd always go over there and visit him at least once a summer for a weekend or something. We'd go to Chattanooga or something. It'd be when he was off a day or something and whatever. And I still remember the first year he was a counselor, and he had what I refer to as the nuggets, the little kids, the very youngest. Sometimes say, well, how the nuggets doing? And he had the distinction once of having to call the parents and say, come get the kid.
Here we're doing, they're doing a lot more.
And that's probably when he was the head counselor or something, that last year. But he's got a great history in Alpine. And he went to Wake Forest his first 2 years, and he said that's where he got involved in Alpine.
You guys
Was
do
back
an
his
Easton as
freshman
well?
year or sophomore
No,
year.
I think he
And he met so many guys from Ole Miss and this and that, whatever. So he transferred to Ole Miss for his junior and senior year. And wanted to do the honors college and stuff and whatever. And that was great experience for him. But he went to school. There was a bunch of Alpine guys. There were some from Wake too. And so, you know, he's been to so many weddings from Alpine guys and vice versa, you know, in his wedding. And there was one day we went to down in, the wedding was in Oxford. I don't remember where the reception was. And at some point they asked all the Alpine guys to come up at the stage or something. It was like 30 yards. Just like a cult, you know. These guys formed such great relationships, you know, the counselors. And even when he transferred to Ole Miss, he said, I'd go to the football games, I'd be walking through the road or something, whatever, and I'd see all these kids, and they'd come up to me and all that, high five and all that kind of stuff. And so, yeah,
They're
he
separate,
really
though,
enjoyed
aren't
his experience on that side of it. Funniest story he ever told me was, he was the first year there, he was as a counselor. He got up early one morning, wanted some coffee, so he went to the cafeteria, so he had a coffee pot and whatever, so he went in and poured, you know, one of those type things, poured the coffee, and he put the thing back down, he turned around, there's Miss O. Did you ever know the O'Farrells? You ever heard about them?
No.
I don't know if they're still alive, both of them or not, but they started in Jackson, Mississippi, they founded it. And, the fellow that runs it now,
I think he's the son-in-law.
so,
Did I have that right?
yes.
Okay. I don't
He's married to
remember his name.
the O's daughter.
Okay.
They call him O's. And so he turns around, there's Miss O. He says, young man, what are you doing? So I just came to get some coffee. Miss O, whatever. He says, you see that coffee pot? He says, you don't ever leave an empty coffee pot. Yes, ma'am. He says, you make
ma'am.
coffee for the next person. Yes, ma'am.
Yes, man.
He said he turned around, and there she was.
Well, it seems like a great camp. We'll send.
So how many of you?
So I've got one son who's 9 right now. He'll go to the short term or mini term, and then we'll send him next year for I think the full 4 weeks.
Short things like right off the bat after Memorial Day.
It is, and it's only like 9 days or something
Yeah,
like that.
yeah. And the others are what, 3 weeks maybe?
4 weeks. I think.
4 weeks, okay, okay.
So
Yeah, he would leave, right after school, or finish in May, his class and stuff, whatever. He was around Memorial Day, they'd report at least a week in advance, and he would be there, I guess, into 1st of August.
Okay. Yeah.
For the summer. And it was a great experience, and, you know, years may want to do that someday. It's a great, way for them to, they really, like I said, he's developed so many friendships with guys with out there. They still, they talk all the time.
We were impressed with every young man we met there, so it was
Yeah.
a lot of fun.
They really got a great group of guys.
Yeah.
It's a cool place. Now, you have a daughter too, though, don't you?
I do. I've got a 7-year-old and a 4-year-old.
So you have to send her to the sister camp.
So the sister camp, well, she's that's DeSoto. She's getting we're out there again this last week.
Yeah, I really like Marshall, and I like it.
Where'd you go?
I mean, it's modern,
down
modern,
below,
but you
south
have this
there.
Okay, my son-in-law.
library
Memphis,
feeling. You guys have
one daughter who lives in Memphis, so they're out of town. And he just went to this weekend over on Savannah.
Oh, yeah. This is the 9. Yeah.
So that was one thing he said. I think he pointed out that he said we'll do the same.
That's cool. That's cool.
Gotta get to
Decide.
My, that daughter, their oldest son is now 3. Well, my son-in-law's father lives in Jacksonville, Illinois, just kind of 2 hours north of St. Louis. So it's on the western part of the state. He's a big hunter.
Oh, I don't think anybody
So
ever
Jake grew up
dedicated
hunting,
long.
so Bo, the little 3-year-old, he got him camo and boots and stuff and whatever. So back, I think it was in November, he decided to take Bo up, just the 2 of them, they drove up and went. Bo,
Good to see you both. Appreciate all the input and the comments and service. I wish I could continue serving with you.
Are you gonna pipe in
I come
quarterly
to find
and
out.
then watch the
I caught a deer.
content live?
Caught a deer.
I may not. But I get you there.
They were bow hunting, and he, granddad, Jake's dad, shot one. And, I said, well, did Bo go with it or retrieve it? He says, no, granddad went, did whatever, he got him fixed up, and we brought Bo, helped put his truck or something or whatever, I don't know. Still caught a deer. Quarter door.
Everybody knew what he meant.
Yep, so,
Yeah.
so he's, it'll be fun to watch him
That's a double busy.
progress in the
Well,
hunting.
then this is you get through, or as you're
I
gearing
don't know
up.
if we'll go very
you
far
want
in it or not, but it was a fun experience.
The national.
I much more enjoy the golf course.
For inspection.
So Jake does a lot of
Everybody
duck
whether
hunting
that's
over in
internal or
Arkansas. It's the
external.
first time I think he'd gone turkey.
Yes,
Yeah,
yes.
Deer hunting up there. His dad, he's hunted all over the world. He's gone to Africa several times. He's got an older house there in Jacksonville, a small town. He's got a room that's just got all the stuff.
meetings with the parents and
It's pretty cool.
the dreaded call. And so the ticket I usually get notified first is that my role. So, okay, let's just not tell the partner because there's nothing they can do about it unright or just be miserable, and they'll make the senior manager, uncomfortable. It'll be like snakes on a plane, But lo and behold, they did notify her, like, as she was ready to go. And so it was just. Let's roll. Yeah.
I mean, this guy's clearly thumbing his nose at us. No, that looks like the
Yeah,
sign.
like Karen just said, we need to get, rolling.
I don't want to mess with Karen.
Right.
She writes checks to us. We don't remember her.
Excuse me, Karen tells me it's 10:15, and so it's time for us to resume our meeting. Thanks, everyone, for being back. At this point, I'm going to ask NASBA Treasurer Andy Bonner to present a report from NASBA. Andy, before you do that, also would like to welcome Ken Abstick. I see Ken has joined us online at some point during this meeting. So Ken is one of the vice presidents of NASBA. So Kent, welcome. And Andy, I'll turn it over to you.
Thank you, Mr. Chairman. I'm going to say right now that when we met in Hot Springs, Virginia on April the 25th as a board, we got to see the new administration under Dan Dustin and all of the different new staff that Dan brought to NASBA, and one of them being our own Wendy Garvin, who departed the state here and went to NASBA. And I can speak for myself and also the members of the board that I talked to at recesses or just over the weekend. We are so impressed with the change of personnel from the leadership down at NASBA. We think that Dan has done a great job picking people. And when we get together as a board, it shows. Their presentations, their ability to tell us what's going on, right out of the gate, the way that they took off, and of course, you can imagine with mobility going on and other issues going on in our profession, as far as pathways and not enough people sitting for exams or not enough CPAs in the workforce, that there were a lot of issues when they came on, and they have really done an outstanding job. As a board member, I'm very proud of the fact that we chose Dan and just the staff that we have has made a big difference. With that, we met on a Friday, the 25th. Maria Caldwell, our chair, and Dan got up with Bill Emmer, Wendy, John Johnson, and also Ken Absek, and gave us an update of everything going on in NASBA. Some of the things that we discussed were 3 large IT projects that we have going on. I know one Jen is involved in, and she's excited about, is the ALD project, which is the accounting licensing database, and they're updating that. There's a lot of collaboration between the executive directors of the jurisdictions and states, boards of accounting, and they've been reaching out and getting good input. That's one system that even when I was the chair of that task force or a committee, you couldn't even see the system. It's so locked down. I couldn't even see what goes on it. And so they're in a rebuilding process, and they've done a great job of doing that and building that, and hopefully by the end of the year this year or before, that will be updated, and it will definitely be an asset to all the executive directors and their staff. Another one is the internal licensing system that helps streamline the internal flow applicants or to sit for the exam or just licensing or CPAs. They're redoing that in NASPA to help get a better turn time on those candidates. And so, and then the other one that's been highly anticipated is the mobile app being updated. And that, of course, is being told to us that that will be out sometime before the end of the year. And so we're excited about that. If you saw the ED's report, Jen actually attached the test scores on the CPA exam, and we went, as we always do, we get an update in that area. We went through and looked at the test scores. We actually are seeing a pickup of candidate volume in February. And of course, this may have a lot to do with the fact that you've got a lot of sessions that will actually go away on that extension deadline on June 30th of 25. And so we're seeing that. The other thing we were seeing was our international volume is down. And just as an interesting note, they told us that our three biggest areas for the exam are Japan, India, and the Middle East. So I thought that was interesting. We got a processing. Of course, NASBA does certain things for state boards. In fact, Tennessee participates in that. They do the CPAs, NIES, and the registry, and from an operations standpoint, all three of those times have decreased. I know a year ago, probably when the exam, or maybe two now, there was some slow times, specifically with people trying to register before the exam changed. And they very much address that, and their times have totally turned around. And it's interesting to see the time lag now is very minimal, which is amazing. As Mr. Monroe reported earlier, the Florida Institute of CPAs and the proposed legislation that is going on down there in Florida. You know, I urge you, as a Tennessee board member, there's all kind of podcasts out there that you can get, whether it's YouTube or LinkedIn. Go out and look at that and see. I mean, I think it's a great example of what happens to your laws and rules when you open them up, specifically the law, and how things can get turned and change when you do that. Also, it gives you an idea of just of some of the major changes that could happen in Tennessee, that if the wrong people get in the wrong spots and try to change the profession. I know one of the things that shocked me was that we heard that that the attorneys were going to be challenged, and that they were going to be challenged like the CPAs were in Florida next year. And so you're just like, wow, this has gotten crazy, you know. But at the same token, I would tell you that Florida opened up their laws and did some things, and it's a great watch. So I encourage you to do that, to see what's happening. We actually had Shelley Ware, I guess the CEO and president of the Florida Institute of CPAs, came into the board meeting virtually and told us what was going on in Florida and gave us a live update of what had just happened that day. And so, and she's done the same on the podcast. So I'll just refer to, you know, reach out, look at the podcast. I think that that's some good information. So between that and really mobility, you know, those were our hot topics for this board meeting. And I asked Jen to, the executive directors, she mentioned that they had a conference, and I know that John Johnson showed a map of mobility and pathways and legislation. And I'll say that the UAA, and I said this earlier, has really approved the new language after the exposure draft. And so I'm going to cover that after this so you can kind of see what the map is showing And then on top of that, you can see, okay, what's the UAA doing to help bring us all back together? This map right here is really gives you an idea of what's going on with mobility across the United States, which is, you know, it affects people coming into Tennessee, and it also affects people in Tennessee going to other places. And, you know, we've got really 25 different legislative matters with pathways and mobility that's going on. If you look at the red states right here, you can see that mobility ties back to the initial licensure requirements that are comparable to the requirements of this state, the state in red, plus an active license in good standing. There's 4 of those. Then you've got, down in Georgia, you've got the mobility tied to holding a license in good standing, passed the CPA exam, and has obtained such education experience as the board by rule may establish as necessary to practice under mobility. So now we have, you know, 5 different states. We got 4 that are one way, we got 1 that's another. Then if you go to the green map, you'll see that mobility is tied to the license in good standing, a minimum of a bachelorette degree. That's the first time that we've had that mentioned, with an educational program with an accounting concentration, and has passed a uniform CPA exam. It says it's no mention of concentration in accounting. In some of the other states. So here's a minimum of bachelorette degree, but it doesn't mention the concentration. And there's 5 of those states. If you go over and look at the orange states, and I will do 2 things here. Notice that Tennessee's in the orange, and also that it is properly circled with the fact that it's awaiting the governor's signature. It says mobility is tied to holding a valid license and has passed the uniform CPA examination, but no mention of passing the CPA exam. And then you've got 1 state, which is Alaska. That's a mobility tied to holding a valid license in good standing, no mention of passing the CPA exam. And then you come down and you've got 1 more state, and it's Illinois, and mobility is tied to the licensing meeting requirements of the home state. However, the licensee does not meet the requirements. The licensee can petition the Public Accounting Registration and Licensure Committee for an equivalency determination of education, exam, and experience. So it kind of reverts back to the old method. So that's 20 states with mobility, and we have 6 different ways to have mobility in those 20 states. So that kind of gives you an idea, and the map's really good in the fact that it comes back down and you can see who's removed the 150-hour references. You can see the removes the 150 semester hours, but adds a BA or a 30 plus 30 pathway. And then you can see which ones are signed into law, which ones aren't. And then the date underneath the ones that are signed into law, that's the effective date of the law. So some people actually went ahead and passed the law, put in an effective date and said, hey, for example, if you look at Utah, they put in 7/1/26, so that gave them an ability to come back and maybe change it after the UAA came together, which makes it also interesting there. So this was updated as of 4/30. So understand that this is going to change a lot as we go through it. And, you know, one of the things that we were hoping for has now happened. The combined UAA committee between the NASBA and the AICPA has now come back, and they have, as you know, they issued a reviews exposure draft with some changed language to Section 5 and Section 23. And now they have actually approved that as of yesterday and sent out a letter to the AICPA and to NASBA now for both of their boards to pick this up and to approve this new UAA. And I'm going to read here. I haven't had a chance to review this, and Mr. Chairman asked me to kind of give you an update of where we are. And so this is my first time kind of going through it, but wanted to tell you that when they asked for the comment period, conclusion on December 30th, 24, they had received 194 stakeholder submissions. It says that 124 comments were from individuals, 7 comments were from CPA firms, 39 comments were from state societies, and 24 comments were from state boards of accountancy. It said there were 2 key themes emerging from the submissions. It was a desire across the profession for additional pathway CPA licensure and broad support for the adoption of individual-based mobility. In response, the boards of directors of both the AICPA and NASBA have approved for further exposure revisions to UAA that will include specifically the educational requirements to sit for the uniform CPA exam, define the requirements for additional CPA licensure pathways, transition from mobility based on state substantial equivalency to model predicted on individual licensing criteria, and encourage adoption of mobility through an individual practice privilege, which is contingent upon meeting established licensing requirements. Additionally, the revised language provides a safe harbor for CPAs licensed under previously approved pathways. The exposure draft, which will be voted on by, NASBA has a call meeting on May the 7th, which is tomorrow. I know that the AICPA had a call meeting that's within the next week. And I've heard 2 different dates, so I'm not going to mention a date. Then at that point, this will be approved. But this exposure draft had changes associated with a post-baccalaureate degree with an accounting concentration and 1 year of experience, a baccalaureate degree with an accounting concentration supplemented by an additional 30 semester hours and 1 year of experience, and a baccalaureate degree with an accounting concentration and 2 years of experience. When you were looking at that map, the reason we had so many different, mobility issues is because we had not come to a conclusion that said, hey, let's meet, let's come up with a UAA, and let's change and have one definition of what it should be. What we're hoping for is that once that these are approved by the boards, then with the changes to Section 5 and Section 23, then we will see a standard, and then each one of those 6 mobility jurisdictions that are different will then come back together, and we will have that individual-based mobility as now the UAA is suggesting. It says the draft permits candidates holding a baccalaureate degree with an accounting concentration to sit for the uniform CPA examination, thereby broadening access to licensure. And as our executive director, Jen, told us today, if there are people out there that now have that 120 hours in a baccalaureate degree, then they would qualify to sit for the exam. And so that's what the goal is, and with 2 years of experience. And of course, Tennessee is in the process of changing that too. It says here, and this is from the Joint Committee, it says, we believe these revisions will strengthen the profession by maintaining a strong pipeline of accounting talent while maintaining the system of cross-border practice currently enjoyed by CPAs. We trust that the revised language, which includes provisions to facilitate individual practice privileges and a safe harbor for legacy for licenses, addressing the concerns raised during the comment period. And specifically, one of the things in this UAA says that anybody who had a license before 12/31/24 would be grandfathered in, and that license would be subject to mobility period regardless of what type of license that they had or pathway that they had in obtaining that license. So I'm excited. This is above and beyond what the board knew at that time, because we were talking about it. We thought it was going to come to this. Now I'll probably get an update tomorrow on this with the board on NASBA. But Mr. Chairman, the UAA has arrived for changes, and we may see those changes happen in the next week.
Thank you, Andy, for the update. Very informative. Are there any questions or comments? Very helpful, Andy. We have other folks who serve on NASBA committees. Any reports? Our members?
I'm on the Education Committee. We've had one meeting, and it was simply to approve funding of research projects, and there were 3 brought for approval. We approved all. Of course, they indicated that the tasks could change as all these issues develop.
Thank you. Others? Mr. Griesbach?
Communications Committee, we've had 2 virtual calls, and nothing of major significance there. We'll have an event at the regional meeting, at least one of them, and probably the annual meeting. So nothing earth-shattering.
Thank you. Others?
Mr. Chairman, I serve on the NASBA AICPA Joint UAA Committee, which actually did meet yesterday while we were meeting, so I was unable to attend that. And I thought Andy summarized things very well. You know, if you could go back in time, I wish that the UAA could have arrived at this point a year ago to provide that model. And it's important to know what the UAA is and what it isn't. It is a Uniform Accountancy Act, but it is a model act. States are free to do what they want to do. They can adopt it. They can not adopt any of it. They can adopt it in part. And just as Tennessee's legacy has been, largely we followed the UAA, but there are some elements where we diverge from the UAA in terms of our either statute or our regs. But the hope would be that this would provide a model that entities that choose to could coalesce around, and so we have a little bit less of a good colorblind test map and a little more homogeneity with respect to that. So particularly for practitioners that cross state lines or national or international firms, it would be great if there was some coalescence around requirements. And I think hopefully we'll get there now that the UAA is on the verge of being approved. And then we, as boards and legislatures, can, you know, make determinations that are informed by that. But again, it's a choice. It's not a national imposition of a solution or a problem. It's just a model rule that provides some sense here, which is now coming through, and that's great to see.
Thank you, Mr. Monroe. Others? I serve on the Enforcement Resources Committee, and we've had, I guess, 2 meetings since the last meeting of this board. And interestingly, Elizabeth Wolf is the staff liaison, the NASBA staff liaison, and she really leads the committee. But she was formerly the board attorney for this board, and but she brings great insight to the committee. One of the items, which is similar to what Duke and Jen heard at the recent conference you attended, was we had a couple of defense attorneys, folks who had defended their clients in cases involving the Board of Accountancy. So these were the defendants, and it was interesting to hear their perspective on what their clients had done and the way they represented them before the Boards of Accountancy. So very interesting information. Do we have reports from any AICPA committees? Andy, I know that you serve on Peak. You may have covered that in your earlier report, but.
Yeah, Peak is going to meet next Monday. With some exciting things as far as just on APSs and what is happening in with those alternative practice structures. We'll be getting into that. I know that they didn't even send out a document for really for an exposure draft. They just sent out a document on APSs to say, tell us what's happening and do we have all the structures? You know, so I know that Peak is picking that up. We've got a really good Peak committee at the AICPA, and I'm looking forward to that meeting. That'll be my last meeting on Peak, and I'm looking forward to that too. That one's really taken a lot of time, But, digital coins will be talked about. And, I'd encourage anybody can go out and register for the open peak meeting. And just as a word to those listening in today, you can get CP credit for doing that. It really is from an ethics standpoint, it's really a great way to see how really the ethics part is changing and for independence purposes and what's happening in our profession. And you get a really good map of how we're having to change and adapt to different scenarios, from cloud-based accounting to digital currency, to international standards and the influences that they're having on our accounting professions here in the United States. And so I'd highly encourage you to consider sitting in on one of those meetings. The Big Four actually has some outstanding people who are regulars on peak, and I know that they actually have peak committees within the Big Four, and so you get the flavor of the larger firms, and I was representing really industry from the fact that I was in banking, and it was interesting to see, to add comment to things that they were saying that we needed to consider when it was very at a high level where really it was affecting other people at a low level. So, and they're very understanding of that, and it's fascinating to sit and to listen to the open meeting. I would encourage everybody here to consider that, but also anybody in the state of Tennessee. I mean, it's an easy pickup of continuing education credits, but at the same time, it tells you what's going on in our profession.
Andy, I use the acronym PEAK, and you did too, but for the benefit of our folks online who may not know what that is, or our visitors, do you mind to tell what PEAK is?
Professional Ethics Executive Committee.
Professional Ethics Executive Committee, so, yeah.
And it's I got on PEAK through being a member of NASPA. NASPA has 3 people who rotate on and off, and they usually, and one of our NASPA or a couple of our NASPA people are small members of firms and or industry, and so I was on there as an industry person.
Yeah. Thank you. Are there other reports? Jen, do you have any updates from?
I do not.
Okay, thank you. Okay, at this time, I would ask Kara Fitzgerald to speak with us, provide us an update from TSCPA. Kara, as most of you know, is President and CEO of the Tennessee Society of CPAs. So, Kara, welcome.
Thank you, Chairman Gilbert, and thank you, Jen, for the invitation to speak with you all today. I'm just going to give a brief update on society happenings. We just wrapped up our fiscal year end at March 31st, so I thought I would highlight a few things that might be of interest to this board, and then obviously talk about some of the legislative activities that have been going on. I know you all have a lot of discussion around peer review. During the last fiscal year, we had approximately 400 firms who were enrolled in the peer review program, meaning they are in the program that TSCPA administers. Last fiscal year, our peer review committee considered 156 peer review reports. I think we've talked about doing a full peer review update to the board at the July meeting, so I'm not going to expand too much on that, but I just want to mention that because I know it seems a lot of times that we're talking about firms that are not enrolled in the peer review program, so I want to share those stats that there are a number of firms who are doing the right thing and who are benefiting from the remedial and educational aspects of the peer review program. With that, we know that there are a lot of firms who choose not to enroll, although they are performing work that is subject to peer review. So TSCPA stands ready to assist in any way we can to amplify the messaging to licensees or to the public about the importance of being enrolled in the program. So if there's things that we can do to publish articles in our magazine or share other information, we are happy to do that to assist the board. Moving on to state-specific ethics, as you know, TSCPA and the State Board of Accountancy operates under a memorandum of understanding for TSCPA to develop the state-specific ethics content. And that was done many years ago to achieve consistency in the ethics education that Tennessee licensees are receiving. And so in conjunction with Dr. Moore over the last few years, we have created that course, and then other sponsors can purchase that course and offer it to licensees. So we're not the only CPE provider who's offering it, but at least we're all offering the same course. During the last fiscal year, we, TSCPA, had 4,093 licensees who took our state-specific ethics course. That does not include licensees that may have taken it from another sponsor. So that's whether it's someone who attended the ethics course at a chapter event, a conference, or took one of our online offerings. We had just over 4,000 folks take that. That's about a 3% increase over the prior year. I'm not sure how much that correlates to the number of licensees who have to renew their CPA license in a typical year, but on average, it's between, I'd say, 3,500 to 4,000 licensees. Our on-demand course continues to be the most popular state-specific ethics offering that we have. One of the main focuses of TSCPA continues to be outreach to future generations of CPAs. So as you all know, we do a lot to get in front of students from high school to college students to bring an awareness about opportunities in the accounting profession. And those types of programs take on a lot of different shapes and sizes, large high school programs that we host in conjunction with universities for students to come spend a day with us, to smaller events where we go visit college classes or beta alpha psi groups, things of that nature. Last year, over all of our student programming, we were engaged with about 2,100 students who attended a number of events across the state. So we're thrilled to be able to get that much interest in the profession. We know not all of them will become CPAs or even pursue accounting, but we do feel that it does make a difference in bringing an awareness and starting to build interest in the profession. So those efforts will certainly continue. Another big part of our student outreach at the college level is our scholarship program. I know many of you have supported that program throughout the years, and it is only possible because of the work of our members and their contributions to the scholarship fund. Last fiscal year, we awarded $280,000 to just over 100 college students in Tennessee. This year, we have $255,000 allocated for scholarships. Those will be awarded in July. So as you know students, or those who may be listening online, if you know students in college, please encourage them to, if they're accounting majors, to apply for those scholarships because it really is a great program. Also want to let you know, many of you knew Doug Warren, who recently passed away. He was a CPA in Tennessee who contributed a great deal to our profession. And our TSCPA Board of Directors a couple of weeks ago approved creating a scholarship in Doug's name. And so we'll be working on what that specific award criteria will look like, but thrilled to be able to honor Doug, who contributed so much. He was involved in the Board of Examiners, was a TSCPA chair, and just did a lot for the profession. So glad to be able to honor him in that way. Moving on to legislation, I know you all have already received the update. I was a bit late because I was at another meeting this morning, but on the pending legislation, the Less is More Act that is currently with the governor for signature. So as you know, as part of the Less is More Act, it provides an additional pathway to licensure as well as addresses mobility so that CPAs who do not have a principal place of business in our state can continue to practice here. It was funny, you know, we were obviously engaged in that and staying very aware as that moved throughout the House and Senate. And as soon as it passed the Senate, the very next day, I started receiving phone calls. And those have continued. And so most of those calls have been from individuals who are currently working at CPA firms have a bachelor's degree, have been working in the profession for some time, and are asking, when can I start sitting for the exam? And so I think as we talked about additional pathways at the society, that was one of our hope, that we would be able to attract individuals who are engaged in the profession and have committed to making a career in accounting, that we would provide a pathway for them to be able to seek licensure. And through the discussions that I have, it certainly seems like there is interest in that. So that's been really encouraging. On May 20th, we are hosting a town hall for students. I think Jen is going to be on that with us, just to kind of brief them on the changes and answer any questions that they have. They've already been submitting some questions in advance. So we're hosting that town hall on May 20th. And then on May 22nd, we're hosting a town hall for faculty and educators to be able to participate. We know there are a lot of questions and concerns about curriculum adjustments, potential rule changes and things of that nature that their students will be asking them about. And so we will be hosting that on May 22nd. So we're looking forward to those events. I know that this board may, over coming months, may be discussing how do you respond to this legislation. And certainly TSCPA is happy to assist or provide input based upon the discussions that we have with members, and especially with students and educators. Moving on to the Florida legislation, which Andy mentioned, I think every state CPA society in the country has been monitoring that. Obviously, it is a very significant deregulation bill. It's not a bill that's just targeted at accounting. It is targeted at all regulatory bodies in Florida. So yes, there is always risk when you open up your accountancy statute. I think that Florida would be facing this legislation whether they had opened up their statute or not to propose alternative pathways. But that legislation, we're monitoring it. It's a broad brush deregulation bill that has three main points: to eliminate all professional and occupational licensing boards, to remove all CPE requirements from regulated professions, and it also would kind of mandate or issue a directive that alternative pathways would be studied, that would provide for pathways that would only be experience or experience plus exam, so meaning no education requirement for licensed professions. And I think that is probably the one that is the most concerning to me, specifically because of the mobility language, which has just been passed in Tennessee, and the impacts that that type of change in Florida could have then on other states. So we will certainly continue to monitor that. Next week, just to mention on a federal legislative standpoint, next week we will have a delegation of Tennessee CPAs who will be in Washington, D.C. For the AICPA Spring Council meeting. We will be visiting with some of our U.S. Congress members, speaking on a variety of issues. One of those is the incorporation of accounting into STEM to be recognized as a STEM curriculum, as well as some tax matters and other things. Moving on to the joint AICPA and NASBA UAA exposure draft that was issued in January. TSCPA did issue a comment letter by the May 3rd due date for that. We issued support, even though Tennessee has passed legislation pending governor's signature. We did want to respond with support for the proposed UAA changes, and applaud both AICPA and NASBA for taking the feedback from last year's exposure drafts and then coming back to the table so quickly with the revised amendments to the UAA. So we certainly applaud those efforts. And then in closing, and I'm happy to take any questions afterwards, but in closing, I just want to share that TSCPA's 94th annual meeting and convention will be held June 10th through the 12th in Chattanooga. It's a great few days of CPE networking, scholarship fundraising. We will say goodbye to our current chair, Kelly Crow, as she moves into the immediate past chair role, and we will welcome Heather Batson from Chattanooga into the TSCPA chair's role. And so we're looking forward to that, and I would invite all of you as board members and all Tennessee licensees to join us in Chattanooga for that event. And with that, Chairman Gilbert, I am happy to answer any questions.
Thank you, Kara. Questions, comments? Your report's very informative, and we always appreciate you being with us, Kara. Thank you so
Thank you.
much. We will move to the new business section of the agenda. Are there any items of new business? Don't worry, I have some, but I'm giving you opportunity first. Okay. I would ask the board members to think. I'm going to have a period of time where we offer comments, but today is the last official meeting for Mr. Monroe and Dr. Church serving on our board. So we're appreciative of all that you've done for us. I have just a few comments, and then we'll ask for other folks to comment. But Pam, you have exhibited unparalleled expertise and insight into accounting education and the function of accounting departments, the development of future CPAs. You selflessly given your time to serve in critical roles of NASBA and this Board of Accountancy, including multiple boards or multiple roles for NASBA and on behalf of NASBA. And we celebrate you and the many gifts that you have shared with us. Thank you.
Thank you.
Comments from board members?
I would echo those too, Pam and Ed, also that Pam has been an accounting educator stalwart in Memphis for all of my career.
About
It
40
seems like
years.
many years. You know, I know in our firm, we had a number of folks that were students of hers, and they always came to us very well prepared and educated, and appreciate all that you have done, and I'm sure continue to do for accounting education in Tennessee and the country, and appreciate your hard work. To the board, and you know, I would just throw out, you went through licensing through all the COVID. It seems like years you were involved in it, and I can't remember if you chaired all those years or not, but the thing I always noticed, you were always very thorough and always offered some compassion for the folks that were requesting extensions. So appreciate that, and best of luck.
And I would just add that on top of everything they just said, how much vision you have brought to this board with education-wise, your students. It never amazes me. I tell somebody I'm on the Board of Accountancy, and they say, "Oh, you know Dr. Church." And so you've had a huge impact in the state of Tennessee on the CPA profession, and thank you for that. But also thank you for everything that you've brought to this board, because it has meant a lot to me. You have definitely opened my eyes several times on thoughts and just the way you describe the actions or the things that were brought before this board that have really led me to believe, wow, I didn't think of that. So thank you very much for all that you've done and for your friendship on this board.
Thank you. You too.
I would just add that it doesn't seem possible that it was 9 years ago when Dr. Church and I were sitting, you know, in a pre-meeting orientation, you know, to try to figure out which end was up on how to serve on this board after we had gotten appointed. And it's been such a blessing to work with you. On occasion, I've had the honor of participating, particularly I think during COVID, you know, talking to one or more of her classes. And my guess, and I think I'm pretty safe in this, is that probably for every CPA in this room, one of the primary reasons that we are here where we are in this room is because we had an accounting teacher or professor that meant a lot and that kind of opened up our eyes to the profession. And Pam has done that for probably at this point thousands of students. And so, you know, you talk about leaving a legacy that will live on, not only here in our boardroom, but just in the profession in Tennessee, thanks to the students whose lives you have touched and whom you have encouraged to become CPAs. And it's just a wonderful thing to envision that is going to continue. And I'm just so thankful to have had the chance to serve with you an entire 3 terms.
Thank you, Kevin. Well, let me say, Brad was president of TSCPA when I assumed this position, and when he asked me about it, I said, I don't think I know how to do that. So sometimes when you're given an opportunity, it becomes a great learning chance, and this has certainly been that. I have just enjoyed it so much. I've told so many people the last few weeks, I never thought that I would miss being on that board after 9 years, but it's really true. And what's made it so enjoyable and just gratifying is that every person that I've been able to serve with has balanced a strict adherence to our standards and a lot of compassion for the people that we serve and for the general public. And I was so afraid that some people might, people can become kind of harsh when they're in roles like this, and I just haven't seen that. I've seen a belief in upholding the standards, and we saw that in the deep discussion today about some of the rules. But I've also, I can remember one person that we had that was just down and out, and there was such compassion for him. So it's been wonderful, and I will miss it. Thank you.
Thank you. And are there other comments? We do have a plaque for you in recognition of 9 years of service. So
I appreciate that. Thank you very much.
And I have the box if you would like to use it, so
I'm
that you
sure I
don't.
need the box to get back to Memphis. Thank you.
Congratulations, Pam. Thank you so
Thank
much. And as I mentioned earlier, we also have Kevin Monroe. Kevin has served this board extremely well and for 9 years. And Kevin also has given selflessly of himself and exhibited servant leadership, your expertise, your talents, and importantly, your kindness to our board. NASBA, your profession, and humanity is noted. So thank you, Kevin. Kevin has served an unprecedented 3 years of leading the board as its chair. And so we are appreciative of that service also, Kevin. And as all of you know, because I've mentioned this over and over, I'm grateful for all of your service on the Enforcement Committee. You do such an outstanding job summarizing the cases and presenting those to us. And I think you're very fair in your assessment of the situation. And again, thank you for that. And I know also that you have given your time to serve NASBA and our profession. And I hear that we might even be looking at a future regional director, hopefully, possibly. But Kevin, thank you for all of your service to this board and our profession.
Thank you. Appreciate it.
Comments?
Kevin, I have to say it's just been an honor to spend the whole period of my service with you, but I feel like I've just gotten a glimpse of Kevin's approach to everything, all responsibilities that he assumes. So I don't know if you are aware that he does extreme service to people going into the ministry, young people going into the ministry, young people pursuing degrees at Lipscomb. Lipscomb's very fortunate to have him, and I'm sure you agree with that, Perry. But he's a servant. That's what he is, and brings with it a great deal of work ethic and integrity.
Thank you.
Thank you.
We talked about new members. I can remember when I first came on, Kevin was chair, and after the first meeting, I said to myself, wow, this is one bright, intelligent, focused individual. And you have continued to show that for my 5 years now on the board. I think we all learn from you, Kevin, every time you open your mouth. You know, you're just incredibly gifted and talented. You bring so much to this board that others have mentioned. And I know I'm better, I hope, at what I do in a lot of ways from having been able to sit and watch you and hear from you and learn from you. And we'll certainly miss you. Thank you for all your contributions. In my mind, you're sort of the CPA's CPA. You know, you're the guy that people goes to for answers, and you always come back thoroughly, succinctly, practically, but also, as I mentioned for Pam, with great compassion and careful thought. And so thank you and best of luck in all you do.
And I'll just add here to everything that's been said, but also just how compassionate you are. I've been fortunate and blessed to kind of come up behind you. You were a year ahead of me, became chair after you, and I still have your little note that you sent me when I moved into that position, and have it sitting on my desk. It's just you're a wonderful human being. You're a wonderful person. You're definitely changing lives in education. Everything you do it to an extent that is above and beyond expectations. You set as one of our members to hire our new CEO and president of NASBA. You were on that task force, and what you brought to that committee that I personally got to witness is coming in as an officer was that your leadership, your knowledge of the profession, and the desire to get the best and brightest and most logical choice to lead NASBA. But you do it from a position of how can I make the profession better? And thank you for that. Thank you for your leadership. And actually, I hope that this is just a segment of like, what's next? And I hope to watch that because you bring so much to our profession, and your leadership is just amazing. Thank you.
Mr. Chairman, I'd like to add my thanks. As Pam alluded to, TSCPA is charged in the statute with coming up with a list of qualified CPAs for the governor's consideration when appointing board members. And well, we knocked it out of the park with two wonderful candidates. And I want to thank you for saying yes. Back in my previous life, I had the honor of working with our board and chairman to identify that list. But looking for an educator, a large firm representative, we could not have done any better. You leave big shoes to fill, but thanks and appreciate your service.
I guess I'd just say to all of my fellow board members, it's been a great journey with Pam to serve with this board and our predecessors for 9 years, and the chairpersons that we've served under, Don Royston and Casey Stewart and Andy Bonner and now Greg Gilbert, have just been tremendous leaders and tremendously dedicated to the profession. And so just appreciate all of the very kind comments, and also would like to thank the staff of the Tennessee Board of Accountancy. Some have served the entire duration of our terms, and some are relatively newer, but all are dedicated and doing their best. And then finally, to the current serving members and to our predecessors, this is a labor of love. You know, we're not, it's not easy work sometimes, where you have to exhibit judgment and compassion on someone who may be down and out, as well as sternness on someone who may be trying to cut corners. And the dedication from each and every one of the colleagues with whom Pam and I have had the privilege of serving throughout our 9 years has been unbelievably great, beyond my wildest imagination. And I normally hope that the governor's office is not slow in making reappointments, but in this case, if it happens to slip beyond July 29th, I hope I can speak with you, Pam. I think we'd be delighted to continue to see this group one more time formally as colleagues, but just thank you for the kind words, and most especially, thank you for the dedication to the profession and to the board. It's very well appreciated.
So two wonderful board members, and thank you both again for your service. I have a couple of proclamations that, resolutions, I should say, that Jen has been very helpful in essentially preparing. And these are related to two of our deceased members. One is Larry Elmore, who served recently as a board member. And the other is Doug Warren, who Kara mentioned earlier. Doug passed away just about a month ago, and a little over a month ago. And so I will read these to you. I think you have copies of them now, but then I will ask for your approval for these. And the first one I'll read is Larry Elmore. 2025 Tennessee State Board of Accountancy resolution by members of the board, a resolution to honor the memory of Charles Larry Elmore. Whereas it is with great sadness that members of the Tennessee State Board of Accountancy learned of the passing of Larry Elmore at the age of 70. Whereas the Tennessee State Board of Accountancy and broader accounting profession lost a devoted public servant and valued leader on March 2nd, 2025. Whereas Larry Elmore was appointed for 3 consecutive terms to the Tennessee State Board of Accountancy by Governors Bill Haslam and Bill Lee, where he served on a variety of board committees, as well as serving as the secretary and vice chair of the board. Whereas Larry Elmore served on various NASBA committees and as the NASBA Southeast Regional Director during his tenure with the Tennessee State Board of Accountancy, working diligently to further NASBA's mission of enhancing the effectiveness and advancing the common interests of the Board of Accountancy. Whereas Larry's kindness and sense of humor made him a pleasure to work with, and he led with commitment to excellence and mentorship. Whereas Larry Elmore was a dedicated member of his community, volunteering his time and skills to serve organizations whose missions were important to him. Whereas Larry Elmore leaves behind a legacy of dedication to the state of Tennessee and the accounting profession that should be a source of great pride for his family. Whereas it is fitting to recognize such a dedicated servant and leader and remember the impact he made on the accounting profession as a whole. Now, therefore, be it resolved by the Tennessee State Board of Accountancy that we gratefully acknowledge the contributions of Charles Larry Elmore to the accounting profession, including the Tennessee State Board of Accountancy, and be it further resolved that we extend our sincerest condolences to the family and friends of Charles Larry Elmore. So that's one. If it's okay, we'll maybe approve both of these at the same time, and we'll have one motion. Larry was definitely a friend to me. He drove me here for my first board meeting, and I know we were with him a good bit. So, secondly, you have a resolution honoring Doug Warren. 2025 Tennessee State Board of Accountancy resolution by members of the board, a resolution to honor the memory of Doug E. Warren. Whereas it is with great sadness that members of the Tennessee State Board of Accountancy learned of the passing of Doug Warren at the age of 69. Whereas the Tennessee State Board of Accountancy and broader accounting profession lost a devoted public servant and valued member on March 28, 2025. Whereas Doug Warren was appointed for 3 consecutive terms to the Tennessee State Board of Accountancy by Governor Phil Bredesen, beginning in 2003, where he served on a variety of board committees as well as serving as chairman of the board. Whereas Doug Warren served on various NASBA and AICPA committees, including serving as chairman of the AICPA Board of Examiners and CPA Examination Reviewer Board, working diligently to further NASBA's mission of enhancing the effectiveness and advancing the common interests of the boards of accountancy. Whereas Doug Warren's support and furtherance of the accounting profession extended beyond his time on the Tennessee State Board of Accountancy through many leadership roles with the Tennessee Society of CPAs, including serving as the 2017-18 TSCPA Board Chair, as a member of the TSCPA Council, and in additional committee leadership roles. Whereas Doug Warren leaves behind a legacy of dedication to the state of Tennessee and the accounting profession that should be a source of great pride for his family. Whereas it is fitting to recognize such a dedicated servant and leader, and remember the impact he made on the accounting profession as a whole. Now, therefore, be it resolved by the Tennessee State Board of Accountancy that we gratefully acknowledge the contributions of Douglas E. Warren to the accounting profession, including the Tennessee State Board of Accountancy, and be it further resolved that we extend our sincerest condolences to the family and friends of Douglas E. Warren. So, any comments or thoughts?
Mr. Chairman, I would just like to say that, there's two tremendously gifted individuals. They will be missed in Tennessee, and they will be missed as friends, too, to several members of this board. Just leaders in our profession. I knew both of them, and they were just, all I can say is that every day I strive to be better because of both of them.
Other comments? Some of you may not have had the opportunity to work with Doug, and maybe some with Larry, too. Larry was recently a member of this board. Doug, it's been some time, but Doug has, as the resolution states, continuously served the profession. Was a personal friend of mine. I actually traveled a good bit with Doug and his wife, and they're really good folks. So I would entertain a motion to approve these resolutions.
So moved, Mr. Chairman.
Motion's made. Do we have a second?
Second.
Those in favor say aye. Aye. Those opposed, no. Thank you very much. Okay, at this time, we will move to the public comment section of our meeting, and I think we have at least one individual who desires to comment. Dr. Moore, welcome.
I'm Perry Moore. I'm ending my 43rd year of teaching accounting at Lipscomb, but the comments today are mine and not Lipscomb. Well, I've got a question, but first a clarifying question to Jen. When this new statute says accounting concentration, what number is that exactly referring to?
So the accounting concentration in statute is set in board rule.
But what number is that? Is it 30? Is it 18?
Oh, number of hours?
Yes.
So to sit for the exam or for licensure?
So it's bifurcated.
Correct, in rule.
Okay. Just trying to clarify. I think it was 8 or 10 years ago, the board had a rule that allowed candidates to sit for the exam before they graduated. I would like to encourage the board to revisit that and bring that back. I think the policy at the time was a candidate could sit for the exam within 200 days of earning their graduate degree. And with this new change with the 120-hour pathway, I could see schools like Lipscomb or others responding in a way where candidates could be sitting while still earning their bachelor's degree. I think the earlier we could get candidates to sit, hopefully prepared, I think the better. Separately, maybe revisit the pathway of the 18 hours to sit and lower it to 15. Just, it's an arbitrary number. I know there's some thoughts there, but just at least looking at what we might do that could help us and maybe other schools. I know, unlike many schools, when the 150 came in, we shifted over half of our hours to the graduate level. Our students, when they graduate with an accounting degree, not counting an internship, they're either getting 18 or 21 hours in accounting. And so they are taking a lot of it. Most of their accounting hours are at the MAC level. So if we can maybe be allowed to go back to the rule, I guess it was 2017, under the Haslam administration, where we had quite a few students who were sitting 200 days prior to when they got their degree. And I would just think, I would ask the board, if there's a rulemaking hearing, that you revisit that, and also maybe lowering the 18 to the 15 of hours to sit. I don't know if, I appreciate the time, Mr. Chairman Gilbert. I don't know if questions to me would be appropriate. I don't know.
Dr. Moore, are you sure about the 200-day rule? I ask because some number of years ago, I was asked to serve on a task force, the TSCPA, and I thought we didn't enact, but we asked the legislature to enact a provision that allowed candidates to sit 100 days before. That's neither here nor there, but do you recall?
It changed over time,
It did, okay, thank you.
but at the end, it was either
200.
180 or 200. I was
Okay.
thinking it was 200,
Yeah.
but.
So my understanding is that, based on my read of statute, and I'll defer to legal to tell me if I'm wrong. My read of statute, as it is currently, says that to sit for the exam, you have to have that bachelor's degree in hand. So in order to make a change there, that would have likely, and again, we can consult on this internally, but that would likely have to be a change in statute that would flow through the legislature in the same way that the new pathway and the changes to mobility did. But it's definitely a good thing to take into consideration.
And you might look back, I guess maybe 2017, 2018 timing, was that a rule change or a statute change?
Okay.
And what it had been before?
Yeah, I will research that. Thank you.
But I know that had been there for many years. Now, when I graduated in the 80s, you had to have the degree, but that was the only requirement. There were no hours requirements or anything. But at some point in my tenure at Lipscomb, certainly after the 150 came in, there was some type of provision that allowed candidates to sit before earning the degree.
And there are other states, that would not be wildly inconsistent with how other states allow their candidates to sit for the exam. There are other states that you can sit for the exam before having the bachelor's degree, so long as you have a very clear path to degree, and, if you don't achieve the degree, then there may be consequences for that.
Well, there was a form, I think, very similar to the certificate of enrollment, but I think it was a little bit different because the register was having to say a little bit more, but yes.
Yeah, okay. Thank you for that feedback.
Thank you.
Thanks, Dr. Moore, and thanks for all that you've done for accounting education during your career, and thank you for presenting the TSCPA state-specific ethics course each year, and well, probably several times each year, but frequently. So thanks for all your work with that. Thank you. You've had one or two students that may have failed based on some reports we saw today, but I think most of your students have done extremely well in the ethics course, so thank you for that. That is not your fault that a student failed, but thank you. Karen, do we have others to make public comments?
No, sir.
No, that's it. Okay. Jen, anything else that needs to be covered?
Nothing from me, thank you.
Okay. Okay, at this point.
One more comment, just, that we got Mother's Day coming up this next weekend. And I just want to thank Jen's mom, who may be watching and hearing her for the first time today on YouTube, for sitting in. At the same token, thank you for allowing your daughter to come and be a part of this board. She is bringing so much to this board. We're very appreciative, and may you have a wonderful Mother's Day.
Yes. Thank you, Andy. Yeah. Great. Anything else? Okay, at this point, we'll entertain a motion to adjourn.
So moved.
So do we have a second? We can stay a while longer if you want. A second. Those in favor, aye? Aye. Those opposed? Thank you.